Sir, you're charged with especially aggravated kidnapping. You're also charged with aggravated assault, and you're charged with theft of a firearm worth less than $2,500.
You're talking about stuff that is not relevant.
Hello and welcome to the Court of Public Opinion. I am the Recovery Addict, and boy do I have a case for you today.
Why is the dog chewing on this guy?
I think they have got the wrong guy there.
Got the wrong guy, and the dog was biting him.
He roughing him up quite a bit. There's a lawsuit.
As the agent for Peyton Ansley John Milton, you are indicating to me that you're quite familiar with Peyton Ansley John Milton, and that's basically you. Is that correct?
I am the agent authorized to represent Peyton Ansley John Milton, as written in all capital letters.
All right, and you understand for my purposes, though that language doesn't make any sense. So
No, I do not.
I understand. Okay, well, I'm telling you that. And so I am, until you disabuse me of the motion, or the notion, I am inclined to believe that you are both the agent and the person. So. And it's in
I'm
all
not a
caps.
person, I am one of the people. Thank you.
Okay, thank you.
I'm not a person, I'm one of the people. Welcome, one and all. Welcome to the Court of Public Opinion. I am the Recovery Addict. I'm not a person, I'm one of the people. I'm sorry you threw me off just a tiny bit there. Good to have you here this morning. Great. Why am I like floating where I am? Who put me here? Oh, I think I did. I did right at the end of the day. We'll go back to regular spot. Good morning. It's great to have you all here, especially... Oh, this needs to turn on. Wait for it. There we go. All right. Still waiting. There we go. Good morning, Lena H. Yes, today's been a rough start. Today, Lena, congratulations on your first in chat. Good morning. It's wonderful to have you here. This day off from the Karen Reed trial. Get a break.
Back, taking it easy.
I did the math. I did the math on today. We officially get 2 half-a-days. We got 2 half-a-days today, as far as half-a-days off. So that's good. Do you have any of that, Court? I need a hit, man. Oh, man. Kurt, I got what you need, man. If you got the goods, I got the stuff. We've got that. Can we experiment with the taillight today? Maybe we should do that. That would be awesome. We're going to experiment with Judge Middleton in just a minute.
About to catch a whooping.
As soon as we do the morning things, we've given the internet to Lena H because she was first in chat. Congratulations, Lena. You've won before. You know what to do. You've been punished accordingly to your crime. So that's good. Are the days off due to scheduling witnesses? Probably. Otherwise, usually judges like to get it done as soon as possible. A lot of them, they never like to wait. They never be like, let's push it to the last minute. We've slated this trial for, X number of weeks. Why don't we take the full time? No, they always like to push it up because, unforeseen things happen. So, Rosemary, no Karen Reed trial today. Believe it or not, justice is still happening across the United States and beyond, in spite of the fact that Karen Reed trial is not going to be held today. And it's hot. And by hot, I mean it is so hot. It's going to be, 87 degrees. And that's outside the courtroom. Oh, inside the courtroom with all the people there and all the bailiffs and the judge in her hot robe, her black robe, which is just like, it's like a black hole for heat. It just sucks it up. It's going to be hot. It's going to be super hot. And the OnlyFans cannot keep up. The AC is too loud. And even though you see microphones everywhere across the courtroom, all along the bar, in front of the jury, all the defense table, prosecutor's table, the judge has one, witness has one, the pulpit little podium thing has one. Those are just for our benefit. They don't help anyone in the courtroom themselves. They can only hear this voice that's spoken as if there was no microphones there. So turn on all the noise, crank up the heat. It would be miserable, mostly for the judge, because she'd be like, Jim, can you turn the fan? Can you turn the air conditioner off so we can hear? Can you keep it up, Mr. Lally? Can you speak a little louder, Lally? Mr.
I'm not
Leslie.
going to argue about semantics.
It's gonna be terrible. So, all right. We have not yet sung the birthday song, which we need to do before we go to court, but we've got a call coming in, and I'm about to miss it because I'm slow. Let's see. Hello? Trying to hear this. Come on. Hello? Hello?
Oh, wait. Hello?
Hello? This is,
Hello?
You're live on the air. Can you hear me?
Nope. Oh, well. That's much.
Have them send someone with more experience.
That was weird. It wasn't plugged all the way in. That was my fault. Call me back. Call me back. I only had the plug partially pushed in. We need someone with more experience. Cables are difficult things for those of you that don't know. Cables are very difficult things. Call back, please. Please, please, please. It was my fault. I will hear you next time. Mr. Pancake, we're not going to post that one. All right. A couple things we need to do before we kick the day off. First of all, Greeners. Thank you very much, my friend. Gifted 5 memberships right out of the gate. Thank you, thank you, thank you. He's just like, I'm just glad.
That was terrible.
I'm just glad we have a day without. What am I missing? Those lights? Anything else? It's like I came in here and don't know how to run my. Okay, so they're calling back. They're calling back. 1 second.
Call from
Uncivil law.
Kurt. I don't know what happened last time.
It
wasn't my fault. Whatever it was. I'm sorry about that.
I literally saw you messing around with your phone live on stream, so it might be a little your fault.
Little tiny teensy bit. A little bit my fault. How are you doing, my friend?
How have you been?
Doing well. This is a wild case with a lot of heated opinions on both sides, but aside from that, doing well.
Yeah, for those of you who don't recognize my voice, this is Uncivil Law from the channel Uncivil Law. We discuss law and legal commentary. I thought maybe we could discuss a little bit about Karen Reed and where things are sitting. I think, generally speaking, people, especially in the YouTube space, it seems to me, are very pro Karen Reed, and I think for very understandable reasons. Mm-hmm. I think they're somewhat undercutting or underestimating some of the strengths of the state's case. They're more than happy to tell you about the weaknesses of the state's case, which are manifest in so many different directions. It keeps you up at night. But the state has done more right in this case this time around than last time,
for sure.
And so I think it's a lot stronger. I think in particular they did a much better job of selling the idea of Karen Reed admitting to or confessing to hitting John O'Keefe. There were more statements from, at least they presented them better, from not only Jen McCabe but other EMTs who were present who said that she heard her say, I hit him, either directly or in the background. And then, of course, you have Karen Reed's interviews, which I think were intersliced throughout the state's presentation very, very effectively. Because rather than sort of getting the one hit, you sort of got reminded over and over and over throughout the presentation. And those statements are capable of being parsed a number of different ways, but one way of parsing them is as an admission. And I think that juries, as a general proposition, really can eat up admissions. Yeah. It's something that they can really latch onto. So I think that is a significant problem. And I think the Commonwealth has also done, although it's ethically problematic, they decided not to call Proctor. It looks like the defense isn't going to call Proctor. So I guess that turned out to be a good decision on their part.
Unless
so they
the
haven't
judge grants the missing witness instruction, which would be pretty huge. I mean, I don't think she will. She denies other things.
I don't know how far
that.
I don't know how far that really gets them, because I mean it's not the same as hearing the testimony. It's not the same as Proctor being on the stand and watching him cringe and squirm. The judge saying effectively, you can infer a negative inference if you want because the witness isn't there. It's it's an instruction in a list of instructions. It doesn't have the same impact. So even if they get the instruction, I'm not, it doesn't necessarily mean that they'll do anything with it.
I think aside from
it's
having
optional
a
anyway.
little bit better evidence this time around, with obviously the phone temperature data, I think that was big. That's not a small thing.
Yeah.
I mean, aside from having a little bit better evidence and obviously doing better with the evidence they had as far as the timelines matching them up better, I think the prosecution has done a lot better simply because they haven't started by defending their position. They haven't started by proving who it wasn't. And you remember how much time we spent talking, on the prosecution's case, talking about who wasn't responsible. They were literally introducing doubt as in their case in chief. So that was a little.
So the prosecution has filtered the evidence to only present the most favorable evidence.
Yeah. And
kept out really bad evidence. You got Proctor's text messages read, but it just wasn't the same.
It wasn't, and it was, and we didn't get the the big C word wasn't dropped, thankfully.
That was irritating.
But everyone's knows what it says, but the effect of actually seeing that and hearing it in court, I think, was diminished because of that. But
yeah, and if the Commonwealth has any particularly scientific evidence that they have been holding in reserve for their rebuttal case, if they can come in with a really solid medical expert or a really solid physics expert, that they can come in with some really solid testimony in their rebuttal case, and then particularly strong in that dimension, then I think the odds of conviction go up. So I saw Polymarket is currently predicting a conviction on first degree or second degree, and second degree comes in variance. So some version of first or second degree.
Do they charge her with first? I thought it was just second manslaughter.
Oh, apologize. I misspoke. You're correct. Second degree murder and manslaughter. You're correct. I misspoke. I apologize.
I could see manslaughter a lot easier than second degree because the intent factor. Just everything was fine at the bar. They're lovey-dovey, kiss on the forehead.
Well, you have to remember what the intent is under second degree murder. The intent is to perform the act, not necessarily the intent to kill. So that's the second degree murder statute doesn't require the intent
to push reverse, knowing that it could.
She just has to have intentionally backed up her car, as opposed to it being accident, as opposed to her slipping on the accelerator pedals, as opposed to she has to have intentionally backed up her car with knowledge that it created the risk, which would be that she knew that he was there and therefore in the path of the car. And then, of course, the fact that the collision led to the death, that led to the actual death. But the intent element is not their problem. Yeah. For me, the weakest problem is the underlying accident occurring. That's the weakest part of the case, not the intent.
So let me bounce a couple things by you, because this might not be a legally sound position that I hold. But I've said from the beginning, I think the prosecution's case is very strong, and I'm worried for the defense in this one. But I am more and more convinced that Proctor did something shady, particularly the evidence by the other officer, the Dighton officer, who said that was not the taillight, that was not the condition it was in when I stood there for 20 minutes outside. The only thing I can conclude from the taillight being in a more complete version, even if it was broken before and pieces missing, but a large chunk of it still being there, the only way those pieces show up at the crime scene is Michael Proctor placing them there, and we then have a cop who is presumably padding the case, planting the evidence to make the case stronger. And it doesn't mean that Karen Reed didn't do it. I'm not, and I don't know what the reasoning would be why someone would do that. Whether it makes them look like a good cop because they found more evidence, or maybe they just want to make sure they get the conviction. Either way, I don't think we can use a corrupt system and reach justice. For that reason alone, I think Karen Reed should be found not guilty, because I'm convinced by the evidence thus far that occurred. Is that?
Well, I think that's a reasonable conclusion. For me, I just like to keep my life simple, and just remember the precise question I'm being asked, which is has the Commonwealth proven each and every element of the crime? So for me, I don't worry about whether or not Michael Proctor framed anyone. I don't worry about whether or not whether Chloe attacked. I don't worry about those issues. I just try to figure out the easiest for myself. What is the easiest way for me to resolve this? And for me, the easiest way to resolve it is simply that the injuries are wildly inconsistent with being hit by a car by 25 miles an hour.
And according to the
just doesn't make
prosecution's
sense.
experts, two experts, they could occur solely from him falling down.
Right. So like that's the easiest way to resolve it. So then I don't worry about any other problems because, you know, it's not the question I'm being asked. I'm not being asked who done it. I'm being asked, did the state prove it? And those are not the same thing.
Yeah.
And so that's how I make my life easy, just by simplifying.
I like taking the hard route. I like to dig down deep and get caught up in the weeds. So, Kurt, I've got a couple things to do this morning. I've got to sing happy birthdays to some people. We're going to watch some court with some of the smaller cases around. But obviously, this Karen Reed trial has captured the attention of a lot of people, well beyond just the local Massachusetts folks. And I know you've done some great analysis and follow up on this, and there will be more, I'm sure. So. Keep it up. I enjoyed talking to you. Thank you very much for the call.
Talk to you later. Bye-bye.
We'll see you. Bye. That was Kurt from Uncivil Law, who one of the lawyers of LawTube, I guess you could call me, being lawyer adjacent or LawTube adjacent would be probably more accurate for myself. But welcome. We're gonna back up a little bit and do the morning thing because we sort of skipped it, and I don't know if we have any birthdays. That have confessed, that have come out in public and announced that, yes, in fact, it is my birthday, or it's not mine, but yours. So please make it known now. You've had plenty of time, honestly. You've had plenty of time to get this done. Let me get this camera fixed. It's just a little too white. Like a little darker in here. Then maybe adjust the focus to... There we go. That'll work. And crank up again a couple decibels. There. Now we're cooking with fire. All right. Good morning. Happy Thursday. It is Podcast Thursday, by the way. We're going to be going to court with Judge Middleton in just a minute, and we'll do a little bit of court hopping. It's going to be a break from Karen Reed for the most part. There's nothing really happening in court. There might be some document issues and some filings that might drop, but other than that. No. I'm just checking the mods. I don't see any birthdays. Or did I miss them? I don't see any birthdays. First time in over a year. Let's see. Maybe I just missed them. Well, you knew it would happen eventually. On a day when everyone thought they had a vacation, what really happened here is somebody went and celebrated and is busy getting pancakes and missed the announcement. So we don't have a birthday to sing to today. I've sung happy birthday every single day. Wait. Buffer see his message. What? Tahini! Oh my goodness, Tahini. You scared the daylights out of us. Why did you wait till the last minute? All right, Tahini, we're going to sing happy birthday to you. Oh my goodness. That was close. All right, we're going to sing happy birthday to Tahini. If you could, everyone please stand up, take a deep breath, shoulders back. It's Marky Mark and the Funky Monk's birthday. Shoulders back, project your voice to the back of the room, blend your voice with your neighbor, warm up with me if you will. We're going to sing to Tahini and Dane. Can we get both of those on the same chat? Tahini and Dane. Happy birthday. Wait. You didn't warm up with me. I could tell immediately. We're gonna do this again. Ready? Warm up with me if you will. La 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 la. There we go. Okay. Tahini and Dane. There we go. Happy birthday to you. Happy birthday to you. Happy birthday to Tahini and Blaine, happy birthday to you. I missed what twice? What did I miss twice? What's your dad's name? I didn't see your dad's name. Where's your dad's name? Quick. Happy birthday to you. Happy birthday to you. Happy birthday, heavenly birthday, JR. Happy birthday to you. There we go. Cheryl Ann, I apologize. I did not see the name JR. Gotcha. All right. Tahini, Dwayne, and a heavenly birthday to JR. Did he sing Dane or Dwayne? I realize there are many special days. Today is your special day. Thank you for celebrating with us. The privilege, the pleasure, the honor, the joy is ours. You could have celebrated with a million people in a million different places, but here you are. Hopefully we can make your day a little more special to begin by helping yourself to free pancakes at Denny's, IHOP Village Inn, Waffle House, McDonald's, Tammy Dunlap's house, Bob Evans, Andy's Grill, and one other place. The Heavenly Bar. I think the Heavenly Breakfast Bar sells them as well. All right. There we go. No court today in the Karen Reed trial because it's too hot. It is smoking hot. The lawyers brought the heat the last couple days, and they just need the room to cool down a little bit. They have a heat wave. They have a heat wave going on there. Messy birthday song. We need more practice. I'm sorry. It was terrible. It was pretty bad. It was my fault. All right. As the song finishes, we're going to jump to court in just a second, but we have a drum solo to take care of before we do that. Everyone join with me. Get the rhythm. Beautiful. You did fine. Did wonderful. Happy birthday to all who are celebrating. Thank you very much. I'm glad we didn't have another sad trombone sound instead of birthday. That would have been terrible. That was the. All right, let's jump straight to court because Judge Middleton is doing what Judge Middleton does best, which is announce that he knows everybody in the whole town and their parents. Let's see what he's doing today. Good morning, Judge. How you doing? Judge Middleton, good morning.
I think you made one payment.
Oh.
But I want you to pay the whole thing off by July 11th. It's really good.
This is the tiniest courtroom. It is so small. But the judge's personality is huge. If you haven't seen Judge Middleton before, he is an amazing judge in a little small town and up there in Michigan. And he knows everybody. He has been here forever.
Here's the ticket that you owe. The case number. I want you to pay it. And I want you to come in here on July 8th. Make sure I got my day right. Yes. And if you do it, then I'll give you time to pay this one. See you at that time.
If you pay one ticket, you get to pay another? Judge, this is a bad deal.
Good morning, Mr. Bush.
Good morning.
Keith, I think that finishes our arraignments. I'm going to take a break here so you can try to catch up with Ms. Davis on Mr. McKenzie. I've got two no-shows, Angela Richmond and Matthew Slavings, to deal with those. Howard, have you got a settlement from me from pretrial?
Okay. This was a pretrial that we did this morning. He's now got a valid Mexican driver's license. I'm reducing it to allowing an improper person to drive. He is Hispanic and they're getting an interpreter.
Oh, okay.
Does he have an international driver's license?
With him?
Basically, I believe we're getting an interpreter for him. Defendant now has a valid Mexican driver's license.
All right, I'd like to see the license.
You can get an international license, right?
So
I'm a little bit confused. He was initially charged with DWLS, but want to see if it'll go to no.
No.
Or they charged it with no ops, and he's going to.
He's charged no ops and a civil infraction of disobeying a
That
traffic.
makes sense. Okay, thank you.
Here's the paperwork.
Thank you very much.
Good morning, Vivian.
Good morning.
All right, I'm gonna be with you in just a minute. I'm gonna step out for a minute. We're shifting gears, then we'll be right back.
Judge Middleton never hits the brakes. He just shifts gears.
So give me about 5 minutes.
Okay.
Well, he does that. We'll go check in with
Judge Chisholm. So as to not punish him, we would ask for a personal bond. I do not feel he is a threat to society nor a flight risk. He has a job. If he doesn't appear for the job, he'll lose his job.
That's how it works.
Unfortunately, with no funds other than a check, it's difficult to post.
Oh, come back. What? He just ended, and I pushed the wrong button. Used the wrong remote. Sorry. Judge Middleton is on break. Give me just 1 second. Let's see if we can find. That one ended, and I had gone back just a minute to see how it ended, but it bit me in the butt.
Commit the offense of uttering and publishing. Do you understand the nature of that charge, sir?
Uttering and publishing?
Yes. All right. That is a felony punishable by up to 14 years incarceration. You understand that, sir?
Yes.
All right.
Uttering and publishing is a felony?
On the other matter, the case ending in 600, in that case, if I can find the complaint here. That complaint alleges that between the dates of April 10th, 2024 and April 11th, 2024, at the location of 423 East Duncan Street in Manchester, Washtenaw County, state of Michigan, that count one alleges that you did steal or retain without consent a financial transaction device. Do you understand the nature of that charge?
Somebody's checkbook or credit card.
That is a felony punishable by up to 4 years incarceration and a $5,000 fine plus court costs. Do you understand that?
Yes.
Count two alleges the offense of breaking and entering a vehicle with the intent to steal property less than $200. You understand that charge, sir?
Yes.
All right. There is a second or subsequent offense notice, which makes this a misdemeanor punishable by up to 1 year incarceration, a $2,000 fine plus court costs. The fine could be increased to 3 times the value of the property stolen. If that's greater than $2,000, that would become the maximum fine. You understand that, sir?
Yes. Yes.
All right. First question I have for you, sir, is do you wish to be represented by an attorney?
Yes.
All right. These are public defenders.
Your Honor, regarding both arraignments, we waive formal reading, stand mute to the charges. And I'm sorry.
Go ahead.
On all 3 cases, I'd request a pretrial date.
Probable cause conference.
I'm sorry. Probable cause conference. Yes.
Judge says, let me help you with this.
All right. You waive time limits.
Yes, Your Honor.
And you're asking for an adjournment on the other one.
Yes, he's going to be in Livingston, I believe, until September 30th. And we would just want to review everything together and see what happens. Obviously, these are new cases.
All right. On these cases, I will
Kathy, congratulations.
adjourn the
12
one
months
case
on the
and set the
jury.
probable cause conference.
Thank you.
For June 26, 2025 at 9 a.m.
Bond will continue.
And I'll get to the bond issue. Let's start with the Ann Arbor case first. Anything you want to say regarding bond?
No, Your Honor, I just asked for a nominal bond. As I said, Mr. Green is going to be in Livingston County until the end of September.
He's
Anything
going to
from
be
the
there a while.
Your Honor, on the, pardon me, on both of these cases, we requested a surety bond of $7,500. And with the reasons explained below, there's a no go-to request on this file for the DFCU financial branch at 25 Briarwood Circle. And I don't believe there's any no contact. That's the only other condition outside of the normal bond conditions on this file.
Mr. Green's
I'll
like,
indicate he's not
bond. Will you guys take a check?
225 Briarwood Circle.
I can write you a check. Big Mike, thank you very much for gifted membership. I did hear, I think you sent me a text message as well about
on that case. I will set his bond at a $5,000, 10% bond. I don't know that there's a necessity to have a cash or surety on this case. I will order standard conditions, including no assaultive behavior or possession of any weapons, no alcohol possession of no alcohol consumption or possession. Also, that applies for recreational marijuana and no illegal drug.
Especially because you're going to be in jail till September, so don't do those things. You should have them in jail.
Yes, sir.
Lena H, usually listening in the background, love reading, chat, and hanging out. 20 months OG status, Lena. Congratulations. And our
On the
internet
other
winner today.
matter, there is a request for no contact with Susan Furda, F-U-R-D-A, as she is a victim in this case. I also requested a no go-to, actually within a 1 mile radius of 423 East Duncan Street in Manchester, as this was a case of break-ins with multiple homes in that neighborhood.
1 mile. 1 mile.
How was her last name spelled?
F-U-R-D-A.
Lori Vallow starts later
no
today.
objection to that, Your Honor.
It's
bond in this case will be set
west.
as a
It's Western, like Pacific and Mountain Time.
$5,000, 10% bond. It will indicate that there's to be no contact with Furda, and he's not to enter the township of Manchester.
Oh, you can't even go to town. You can't even go to Manchester. That's a huge one. KR is closed today because of the temperature. It's too hot.
Anything else on that?
You want that no go to as well on that file?
He's not to enter the township of Manchester.
Oh, okay. I didn't hear you. Thank you.
Nothing else for me, Your Honor.
All right.
Camille, we're not planning on following that
We'll be
trial,
in touch, Mr. Green.
but we might pop in just today. If depends what else is happening in some of the other courts we're watching as we court hop. We might have something out of Tennessee to watch instead.
Burkos case, People versus Mary Collins.
Katie Bug, 9 months.
Permission to practice is granted.
Thank you.
Good morning, Your Honor. Edward Dukas for Mary Collins this morning. I'm standing in for the attorney record of Kyle Burdell. I have a substitution form for the court that's signed. Not in the file, but will be.
All right. Very good.
And this morning I'm asking for an adjournment. I understand the discovery got sent over yesterday. Still need some time to go over that. I don't know if there's any outstanding discovery. I'd ask for an adjournment at the court's discretion.
Objection, probable cause conference will be adjourned to June 17th, 2025, 9 a.m. That's a Tuesday.
Okay, thank you.
Thank you.
Does she want to buy a taillight?
Court calls case, People versus Ayden Henderson.
And for that is for the people?
Good morning, Your Honor. Kerma Dadish on behalf of Ms. Henderson, who is appearing by Zoom. Ms. Henderson, can you please state your name for the record?
Ayden Henderson.
Thank you.
You're welcome.
Requesting an adjournment.
Yes, Your Honor, we are going to refer her to our AIM division and to continue plea negotiations with the prosecutor's office.
How long is she going to be in Wayne County Jail? Does she know?
A while. I believe they're doing a competency report there, so it's going to take a minute.
So
we can adjourn it out.
So there's a comp on her case there?
There, yes. I'm debating whether I need to talk to
Counsel approach.
the seniors in our office.
Counsel approach.
Yeah.
Or you can keep talking. Counsel approach.
Oh, counsel approach.
I think that's an approach.
Get up here, he says. We need to talk. Rona, welcome to the gallery. 18 months celebrating that. That is awesome. Congratulations. Thank you for your support. Also, OG Sean White says it's disgusting. Here, it's 9:30. It's already 85 degrees. Okay, you have to realize, for those of you who live in hotter parts of the country, right? I know it's not as hot. I know some of you say, we get, I might have to cut away. Okay. As long as we're not changing right here on camera.
All I do is talk a lot. Shut up and be quiet. Nobody got time for all that stuff. Y'all see me in court. Y'all want to play like two little kids. Y'all not getting no snack when we get back home. You hear me? Do you hear me too? Josiah is not funny. Don't say nothing else. I'm gonna be back on here in a minute. I'm gonna give y'all some crackers. I'm gonna give you anything else.
I think the competency hearing is the right call, just to make sure she's okay. What sucks is jail is the worst place for somebody who has, some sort of condition like she appears to have. It's terrible. It is absolutely terrible. The treatment is just not there. The environment is terrible. Hopefully that competency hearing can be conducted rapidly. I was talking about the temperature.
On this case, what I will do is I'll adjourn the probable cause conference, understanding that I may get a request for a competency or forensic evaluation to coincide with the one in Wayne County, but I'll adjourn this to, we'll just do July 10th initially, and then we'll see where we are.
Thank you, Your Honor.
July 10th, 2025, 9 a.m. On continue.
Some of these places that are getting warm, like the courtroom in Karen Reed case, they're just not built to handle the heat.
Versus Aaron Fromm.
They don't have the AC. They don't have the capacity to cool that much. What?
Sherilyn Foster Tucker on behalf of Aaron Fromm.
Aaron Fromm?
And Your Honor, we're just requesting a brief adjournment to review discovery.
Probable cause conference will be June 17th, 2025, 9 a.m. That's Tuesday. We'll continue.
Thank you, Your Honor.
You should not be getting commercials. It's possible you might get one at the very beginning. You should not be getting commercials. I did not insert them.
Court calls case of the people versus Winona Harvey.
On replay, I think YouTube forces me to allow commercials to be inserted, but during the live, you should not have any. I would hate it. I would hate it if you're getting commercials. I fight YouTube constantly on this front.
Chinaza.
We're going to grab it right now, Your Honor.
We're missing a lawyer.
Really? Ma'am, state your name.
Winona Shell.
Thank you.
And your lawyer's not here.
Where is she?
we might see a different side of the judge here in just a minute.
Somebody needs to get her in here or have somebody that can cover this case now. Thank you, Mr. Gaddy.
Morning, Judge Mike Gaddy on behalf of Ms. Harvey. You spoke with me? Yes. Okay. What's gonna happen?
So, we're gonna talk about somebody that I hit.
Okay, no, did she tell you whether the case was going to?
Yeah.
Well, you need to pass this case, Judge.
No.
Judge doing the clappy hands. He's not happy. When this lawyer comes back in the courtroom, he's going to have some words for
I think this may be a referral.
Parental.
Yeah, sure. I'm trying to.
She told me that I'm here about a case about putting my hands on an officer at the correctional facility.
Okay.
That's what I'm here for today.
Yeah, Your Honor, we're going to refer this for competency. I'll prepare the competency referral and the, criminal responsibility referral forthwith.
Forensic evaluation is ordered. I'll set a competency hearing for 90.
August 28th.
90? Okay. Say it again.
August 28th.
August 28th, 2025.
Thank you.
9 a.m.
Thank you, Your Honor.
I have a court date August 28th,
Bond will
2025.
Yes.
What month is this? June?
This is June, yes.
It comes after June.
Well, I'll come visit you in the back, okay? July comes after June. Okay.
Court calls case People versus Charles Tingley.
Our attorney didn't show up.
Your Honor, good morning. Joe Simon on behalf of Mr. Tingley, who should be by Zoom. Is he?
Mr. Tingley, you there?
Tingley?
Bench warrant.
I am Charles Tingley.
Oh, here he is.
Okay, I'll need a camera.
It was just here.
All right.
Well, he's dressed appropriately and everything. That's great.
Your Honor, I'm informed that the long-awaited contract with Detective Babbage in the county has been signed, and we are asking the court to grant our request for another adjournment. We're trying to be one of the first cases in line since we've been waiting, but I can't assure you of that. So,
what's the anticipated time frame?
Well,
The only information I have is that I believe the contract has been signed, and so he's going to start scheduling them.
Got it.
So maybe 3 weeks, if that's.
Unfortunately, I'll be gone at that time. So, but
beautiful. We'll set it then.
Beautiful. We'll set it then.
Thank you.
Regina Crawford.
No, I want you
gifted
around.
5. Thank
If
you.
you're around and Miss Landy's there, we learn things.
We do further our education. That is true.
I'm so full of nothing out. I am. It's a joyous time when you learn things.
It is.
So
that is true.
What date do you want?
Could we possibly go to July 10?
Is there any objection from the people? Probable cause conference, July 10, 2025, 9 a.m. Bond will continue.
Thank you, Your Honor.
I think that's the quietest Landy's ever been. All right.
Mr. Tingley, you're good. You're done.
Bond will continue. Thank you.
Thank you, Your Honor.
Court calls the case People versus Molly Fox.
Molly Fox. This judge is
Ellen
one
Dennis
of
appearing
our
on
favorites.
behalf of Molly Fox.
Oh, I didn't realize she was a lawyer. I thought she was just like a switch. There we go.
Your name?
Molly Fox.
All right, what are we doing?
Well, Your Honor, this is a PCC conference, and we've had many adjournments, but what I would like to see happen today is that the court would reinstate Ms. Fox's bond and let her get out. And I would say that Jacob Kennedy and I have had many discussions about resolution here, but we haven't really come to a conclusion. And he sent me the paperwork on the recovery court, which I discussed with Molly
What is
Fox.
going on
I
here?
went to visit her on Sunday and talked to her about it. And we went through some of the responsibilities and what would be expected of her if she be accepted in such a court. I believe that she could do that, but only if she has strong family support. So I urged her to, what I would like is for her to get out so that she can talk to the family members, which are, in my opinion, their involvement and support is absolutely essential for her to be able to complete the recovery court.
The judge wants
program.
the Cliff Notes version.
The other matter is we have never really come to a conclusion as to what the plea would be if she were to go into the recovery court. So I would like to have an adjournment of the PCC, but I also would like to have her released again on bond so that she can do these things and come to some kind of conclusion.
Well,
I thought he was
stop using cocaine.
Well, of course she does. Absolutely.
Soundbite.
And she, she did complete the first 8 weeks successfully of the Dawn Farm program. She doesn't, that's the other thing. She doesn't know whether they would let her back into the program or
They
let
should
her.
actually be able to re-enroll.
Okay, so what do you want me to do with, you want this adjourned?
Well, yes, but I wanted to be adjourned with a release of her from custody and go back on the bond if possible. Because she's had
Okay,
kind of.
I don't negotiate that way, but that's okay. I don't know that I'll release her. I don't know what you want me to do.
Well, as I did make out an adjournment paper.
Do people have a position on bond?
Yes, sir. In this case, involved a situation where the defendant was intoxicated. That's why she failed the test. And then while she was on, I don't think that a release is appropriate without a rigid substance abuse treatment plan in place, which there is not.
Well, I'm informed that the Dawn Farm program would let her back in. I don't know for sure. I can't represent to the court that that's possible, but she seems to think it is. And that's a pretty, she was attending AANA once or twice a week. She was doing group program, and she did that for 8 weeks successfully. And then, she had the incident where she used cocaine again.
2 incidents.
2 incidents, sorry.
Yeah. Probably more because there's a lot of abnormal creatinine. She was using. So the issue from the court standpoint is this. I am not going to release her or change her bond until there's something in place so that she's at least receiving some treatment or something along those lines or some program. It's not going to happen. Give you time to put that in place or to try to figure out what that's going to be. And I'd suggest that you talk with the prosecutor's office and try to work something out that is structured for this individual. So your motion for bond modification is denied. I will adjourn this matter to June 26, 2025, 9 a.m. The bonded.
Your Honor, just sort of my own information, if I were able to determine that the Dawn program would let her back in or let her restart or whatever, would that suffice from the court's point of view?
Here's what I'd suggest. If you were to confirm that there would be something in place for her treatment, I suggest that you get with the prosecutor's office, see if the two of you come to some type of agreement. If you can't, you can file a motion, I'll hear it, or
Hello,
we'll
inmate.
hear it on the 26th.
Welcome.
Okay,
Thank you, Your Honor.
thank you.
Inmate's using the Zoom cam as a mirror. Checking his hairstyle. Ah, we have a name.
Case, People versus Christopher Gilmore.
Ayden, on behalf of the people, Your Honor. Good morning, Your Honor. Wendy Burnwell standing in for the attorney of record,
What
Kareem
is she wearing?
Johnson.
Is that a fan? Is that a
Your
personal
name,
fan?
sir?
Around her
Mr.
neck?
Gilmore, good morning, Your Honor.
Good morning, and you have no objection, Barnwell stepping in?
No, no, sir.
All right. All right, what are we doing?
Your Honor, Mr. Johnson has indicated that he received all discovery and he wishes to set exam dates on both cases.
People have the witnesses available on the 17th.
My best, Your Honor. You said June 17, Judge?
Yes, sir. Yes, ma'am.
When did
Preliminary examination in these matters in person, June 17th, 2025, 9 a.m. That is before Judge Moore.
Permission.
Thanks today. If I can leave.
Your Honor, there's an ongoing discussion because my client wishes, Mr. Johnson's client wishes to have permission to leave the state. However, I'm indicating to him that the court would want that in writing. And the court would want
What's
defense
his
counsel.
purpose for leaving the state?
Right.
Your Honor, I'm about to turn a new leaf, Your Honor.
Pardon?
Can't just,
I'll-
the case has to be resolved.
All right.
You just want to leave the state?
Yeah, I'm tired of getting in trouble. My summer, I don't want to spend my
You don't
summer.
like the great mittens to the north? Go ahead. You just want to leave the state while criminal charges are pending? Probably is not going to happen.
All right, thank you so much.
Yep, okay, great, that's, glad we're,
Your Honor, I'm just tired of the
Thank
state
you.
trying to
Have a
get
good
in
one.
trouble. I'd like to leave now if I could.
that was easy. Court calls the case, People versus Marvin Sullivan.
James Fifelsky appearing on behalf of Mr. Sullivan, who is approaching.
I got a neck fan.
Can you
My
state
kids
your
use
name
it.
for the judge, please?
Marvin Sullivan.
Your Honor, at this time, we will ask the court to set this for preliminary
All
examination.
discovery is complete.
Yes, Your Honor.
People have their witnesses available the 17th.
Is it any way possible to go 1 week to the 24th? And I will represent the court. I understand that Mr. Sullivan has a hearing in front of Judge Conlon on an extradition on the 25th. So I don't think this would be holding him any longer than he on this case than he would be otherwise.
Oops, sorry.
I'll leave it to the court's discretion.
That's the neck fan that I bought. There in chat.
Preliminary examination in person,
My kids use
June
it all the time.
24th,
It might be good. I never
2025.
get to use it.
9 a.m. before Judge. Fresh hour. Bond continued.
Thank you, Your Honor.
Court does call the case of People versus Alexander, is it Bounds?
Your Honor, Student Attorney Kara Rosengren, under the supervision of APD Stephanie Cannon, on behalf of Mr. Bounds. Mr. Bounds, could you state your name for the court?
Alexander Bounds.
Your Honor, we're requesting that the court set a date for Mr. Brown's preliminary exam.
All discovery is complete.
Yes.
People have their witnesses available the 17th. Preliminary examination in person, June 17th, 2025, 9 a.m. Actually, that's at 12 noon. That is before me.
Thank you, Your Honor.
Bond continued. Thank you, sir. That's in person.
Yes, sir.
No more Zoom for you.
Court does call the case of the people versus Elliot Kazan.
Ready, Your Honor.
Castellani for the people.
Oh, you're still here.
I
Mr.
return,
Sharp.
Your Honor.
Oh,
Mr. Sharp's enjoying watching this show.
Picking up knowledge. I'm sorry.
Joe Simon on behalf of Mr. Kazan. Your Honor.
Your name, sir?
Elliot Kazan.
Thank you.
Your Honor, I may request approach the bench, but I'm a little afraid. The last time we were here, we were about ready to enter a plea. Then we had our bond issue. The people have maintained the offer. My client wants to accept it. But could we approach briefly?
Yes, you can.
Thank you.
Oh, it's both you two.
Yeah, that's all a little.
All right. It's a quiet morning this morning. We haven't checked in with Judge Simpson in quite a while. Mr. Sharp there is enjoying watching the Zoom feed. I got a neck fan thinking it would help me stay cool in the hot days of summer. And it might if I ever get the chance to use it, but my kids wear it all the time. And then they bring it to me when it needs to be charged. And so I charge it. I'm like, oh, I'll get to use it. And as soon as it's charged, it's gone again. The kids use it again. So we do have a sidebar, a rare sidebar. Neck tube cooling is way cooler than a neck fan. Is that where you have like the gel, that gel pack thing that goes over the neck that's like stays wet? Is that? I saw the neck fan. I've also seen like the belt pack fan that sort of like quite literally blows up your shirt. So it makes you look like the Stay Puft Marshmallow Man because it just inflates your shirt. You wear it on your belt and you wear your shirt untucked, and it just like blows air up, and it cools you. It's a funny look, but fans are good for work. I try to avoid the work. That helps as well to stay cool. I have gel ones on neck bands, and I freeze them. Works great. Oh, ice on the neck. Ooh, that's cold. I think that's what some of the Disney characters have in the parks have to keep cool. Man, that's tough work being in a costume all day. And those costumes must get pretty ripe, you know? I mean, that's for hot flashes too. There you go. Sidebar's taking a minute. Let's see if we can find another court we might be able to jump to. I've heard rumor that Judge Wolf may be streaming today. Let's see. Out to Tennessee. It would be nice. We haven't been there in forever. I missed the Heavenly Wood courtroom. All right. Judge David Wolf, not yet live streaming today.
And to be clear, Your Honor, my client did fill out previously an advice of rights form that I
equate that with riding lawnmowers.
Man,
go ahead.
Riding lawnmowers.
I'm sorry, Your Honor. My client did previously fill out an advice of rights form, but I re-reviewed that with him. And he knows that he previously filled out a sentencing judge waiver, but he also knows I've reviewed that with him as well. Please write it in his please.
All right. The plea form in this case indicates that the defendant will be pleading to 3 charges. That he will be pleading to the possession of a firearm under the influence, the actual stated count 3, as well as an addition, and that's the 93-day misdemeanor. He will be pleading also to operating while visibly impaired first, a 93 days. And will be pleading to attempted possession of a loaded firearm in a motor vehicle. And I believe That's a 1 year. It's not on.
That is a 1 year, Your Honor, and I do believe mandatory forfeiture is a component of the offenses that the defendant will be pleading as well.
That's 1 year. Fines on that are.
1,000?
Yeah, I think so. I think that's right.
1,000. A lot of fines.
All right. And then counts 1 and 2 would be dismissed. And
The people are agreeing at the time of sentencing not to.
no upfront jail if defendant remains compliant.
Correct.
Okay. All right. May I have him sworn?
Raise your right hand. Do you solemnly swear and affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth? So help you God.
I do.
State your name.
Elliot Kazan.
All right, sir. Is this court's understanding that you are going to be pleading guilty to 3 misdemeanor charges? Is that your understanding?
Yes, Your Honor.
All right. First charge is a stated count 3 of possession of a firearm under the influence. That's a misdemeanor punishable by up to 93 days in jail, a $100 to $500 fine plus court costs if you were using and or discharging the firearm. Also mandatory forfeiture of the weapon or device. You understand this?
Yes, Your Honor.
All right. Also, this court's understanding you're going to plead guilty to the charge of operating while visibly impaired first offense. That's a misdemeanor punishable by up to 93 days in jail, $300 fine plus court costs. Court could order rehabilitative services or any community service court deems necessary. Court could order your vehicle immobilized. Court order you to pay the cost of the prosecution as well as the cost of any emergency governmental services. You understand that?
Yes, Your Honor.
All right. Also, count 5 of attempted possession of a loaded firearm in a motor vehicle. That's a misdemeanor punishable by up to $1,000 fine plus court costs. You understand that? And also mandatory forfeiture of the device. You understand that?
Yes, Your Honor.
You also understand, sir, that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Freshour in the 14A3 District Court.
Yes, Your Honor.
Understanding all of that, you still wish to plead guilty?
Yes, Your Honor.
All right. To the charge of possession of a firearm under the influence, how do you plead?
Guilty.
To the charge of operating while visibly impaired, how do you plead?
Guilty.
To the charge of attempted possession of a firearm in a motor vehicle, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you will not have a trial of any kind.
Yes, Your Honor.
You signed an advice of rights form previously, is that correct?
Yes, Your Honor.
Any questions regarding those rights?
No, Your Honor.
Please look at paragraph 5. Those are your rights, which are part of a trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes, Your Honor.
You understand you're giving up your right to appeal of right.
Yes, Your Honor.
Are you on probation or parole?
No, Your Honor.
Has anybody promised you anything other than what's been stated here today in the record to get you to plead?
No, Your Honor.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily?
Yes, Your Honor.
Of your own free will?
Yes, Your Honor.
And because you believe that you are indeed guilty of these offenses?
Yes, Your Honor.
June 22nd, 2023, at the location of Jackson Road near Stabler Road, Scioto Township, Washtenaw County, State of Michigan, were you operating a motor vehicle?
Yes, Your Honor.
Prior to operating that motor vehicle, did you consume intoxicating liquor?
Yes, Your Honor.
What did you have and how much, if you recall?
5 to 6 beers.
Were you stopped by the police or was there an accident?
I was stopped by the police.
Why'd they stop you?
Rolling through a stop sign.
All right. Were you ultimately arrested?
Yes, Your Honor.
Were you taken to the station or hospital for a blood draw?
Yes, Your Honor.
And what were the results of that blood draw?
0.095 blood alcohol level.
Do you have any reason to dispute those blood test results?
No, Your Honor.
Taking everything into consideration on that date and at that time, do you believe that your ability to operate that motor vehicle was visibly impaired due to your consumption of alcohol?
Yes, Your Honor.
In that motor vehicle that you were driving, did you have a firearm in it?
Yes, Your Honor.
And where was it?
In the glove box.
All right. And did you have authority to carry that firearm in that fashion in that?
No, Your Honor.
And I think that's and at the time you were under the influence and you had possession of that firearm?
Yes, Your Honor.
Counsel?
Was the firearm loaded?
No, Your Honor.
Well, actually, what?
Yes, it actually.
Okay.
Yeah.
Was
Yes,
the firearm
ma'am.
loaded?
Yes, I had. Yes.
All right.
In the magazine, not the chamber.
Yes. In the magazine, not the chamber. Yes.
But nevertheless, that constitutes.
Yeah. Same. Yeah.
All right. Now, counsel, have I complied with the court?
I'm satisfied, Your Honor. Thank you.
Yes, Your Honor.
Court will accept the defendant's pleas of guilty to counts 3, 4, and 5. Counts 1 and 2 are dismissed. Pre-sentence investigation and report is ordered at 14A3 probation. Sentencing in this matter will be. I'm sorry. We're on the wrong thing. Yeah. Give me that sentencing date again.
June 16th.
Sentencing, June 16, 2025, 9 a.m. Fresh hour. All right, Esteban.
Your Honor, we are requesting the court reinstate my client's bond. His original bond was 5,000, personal recognizance 5,000. He was ordered to community corrections to participate in SoberLink testing. The last time we were here, we offered to switch from that to a scram tether. That's our request, is to reinstate bond with the scram alcohol tether.
Anything from the people?
Your Honor, the people's concern is that the defendant not be consuming, so a scram tether will accomplish that goal at this time.
I'll reinstate the defendant's previous bond condition. So he set his bond $5,000 personal recognizance bond. The defendant is to be placed on a scram tether prior to his release. I will sign that order, and I know you're trying to work through that, so we'll sign it and make sure that it gets over there.
Thank you very much, Your Honor.
Thank you, Your Honor.
All right, thank you.
Thank you.
Court does call the case People versus James Sharp.
People.
Diana, let me pause the judge for a minute. Diana, happy birthday. I'm so sorry we missed you. Happy birthday, Diana. 35th. Free pancakes, Denny's Waffle House, IHOP, all the places. I am so sorry. So sorry we missed you. You thought it registered. We didn't have it on the list, unfortunately. So sorry.
We'd ask the court to set it for the 24th.
Is all discovery complete?
Yes, Your Honor.
Would the people have their witnesses available on the 24th?
Attempted possession of a firearm.
Preliminary
pretty much describes
examination
my
in
youth.
person, June 24th, 2025, 9 a.m. That is before Judge Wash.
That was pretty much my whole.
Thank you very much, Your Honor.
Continue. Thank you.
I like shooting.
Court calls case People versus Sterling Paris.
Alexander, on behalf of the people, Your Honor.
Good morning, Your Honor. Wendy Barnwell on behalf of Mr. Sterling Paris.
Your name, sir?
Rick, thank
Sterling
you.
Paris.
Thank you.
18 months.
Okay.
Wow. Client just barely got the name out, and it's maybe approach. Rick, 18 months. Slowly climbing to OG status. Love this channel. Thank you, Rick. Appreciate your support. Love that you're here. Wouldn't be the same without you. Happy birthday. Let's do a quick verse for Diana. Can we do that, everybody? Here we go. Have one more birthday song. One verse. Ready? Happy birthday to you. Happy birthday to you. Happy birthday, dear Diana. Happy birthday to you. There you go. Diana, we didn't miss you. We sang to you. It was just a little late. Apologies. Happy birthday. Got the dancers, you got the cake, you got the party horns going off. There you go. And Nico even did the air drum thing. So, let's see. Virgo says, I'm glad it's a read break today. I miss being here. I couldn't do another Karen Reed trial. You were not alone. There are a lot of people where this trial is too much. And for that reason, I'm looking forward to the end of the trial. I am still fascinated by the legal aspects of the Karen Reed trial, but it was long the first time around, and it's long the second time, and it'll be good to be on something else. Alicia, woohoo! 2 months, Alicia, that is awesome. Thank you for your support. Welcome to the gallery. Love that green courthouse by your name. changes colors rapidly in the beginning. Regina says, since no Karen Reed, I might get some real work done. Mr. Stewart is just chilling. He is kicked back. I think we've got a sound effect for that one. Right here.
I was kicked back, taking it easy.
Right there. Can we dip into Diddy? No. Greeners, no. Nope. Not even a little bit. Weebug, sorry to hear about your
complaint.
Oh, but can you come talk to me?
All right. Thank you.
I have other cases in here.
Can you come talk to me? I have other cases.
Court calls the case. People versus Jody Williams.
Ready, Your Honor.
Ayden, on behalf of the people, Your Honor.
You're just everywhere.
Pardon?
You're everywhere.
It's been tough. I'll get my steps in. Joe Simon on behalf of Ms. Williams. Jody, state your name.
Jody Williams.
Thank you.
Your Honor, we're asking the matter be set for preliminary exam. And because you always know I never cause trouble for the court, what is the earliest possible? Because my travel dates are both on successive Tuesdays. I'd like to have this sooner than the 24th if possible. I travel on the 24th and then on July 1st. So
Oh, so you want us to accommodate your scheduling
if
on
possible,
everything?
if possible.
That's an arrogance I haven't seen in a long time. Will the 17th work for you?
Yes.
All right. So
Thank you.
Discovery is complete.
Yes.
Would the people have their witnesses available the 17th?
We'll do our best, Your Honor.
All right. Preliminary examination in person, June 17th, 2025. 9 a.m. That is before Judge Moore.
Wait for me outside, okay? Thank
Bond-
you. Oh,
Bond
sorry.
will continue. Thank you.
Thank you, Your Honor.
Bye.
I'll
That's a
see you
good soundbite,
on the
too.
next docket on Zoom. But Your Honor, I will say this, it's always an uplifting experience.
Wait for me outside, okay? That's a good soundbite.
Back at you. That's all I got. Court calls the case People versus Wesley Brand.
Ayden, on behalf of the people, Your Honor.
Good morning, Your Honor. Wendy Burnwell on behalf of Mr. Wesley Yonda Brand.
All right. What are we doing? I think I have a conditional release
They're gonna address
violation.
violation because
Your
you made a
Honor.
call
You've been
and they're
prosecuted
describing all
jail
this
calls. On our
allegedly.
records, we have 17 complete calls to the victim since he was arraigned, as well as 84 total attempt in threats. So he's tried to call her a total of 84 times, with 17 of those calls getting through.
84 times calls the victim. 17 got through.
Counsel.
Guess
Your
what?
Honor, this
The
is,
bond violations. Why don't we start there?
Your Honor, this is, didn't have enough time to talk to him about the particular alleged bond violation, Judge. I did read it yesterday. It was sent to me and I did read the bond violation.
And does he want it set for hearing? Or
1
does
second,
he
Judge.
admit to the violations? Gonna need a,
Okay. This way.
They've got you on tape calling 82 times.
Yes, Judge.
what are we gonna do?
It's just to set it for a hearing, Judge.
It wasn't me.
I'm assuming it's another day.
Yes.
Okay.
Set a bond violation here. Gonna have room on 12.
Yes.
So I'll adjourn the probable cause and set a bond violation hearing for June 12th, 2025.
Split second,
at
Judge.
3 p.m.
I'm here.
Pending that hearing, defendant.
I'm here, Judge. I'm here in front of this court that same day.
All right.
So
So that's at 3 p.m. And
So that's not a competing.
pending that
schedule.
hearing, defendant's phone privileges are hereby ordered revoked.
We are watching carefully well, let me see. Let's go back to, let's go here. We are carefully watching another court
It's bond, however.
which we have not been to in
Thank
quite a
you.
while. It's this one down here, Judge Wolf, who just
Judge
barely
will set
took
an
the
exam
seat.
day on that day.
That's what you wish.
Thank you.
Court calls case People versus Derek
I
Stewart.
think we're gonna jump to Judge Wolf.
APA Rachel McDuffie for the P.
Oh, he's not dressed yet. Look, he's still in his civvies, not skivvies. That's different. We'll keep an eye on him.
Public defender case. No one was assigned to it.
No one responded.
We'll go to
I'm
Tennessee.
here, Assistant Public Defender Jay Bellinger, on behalf of Mr. Stewart. It sounds like Derek Stewart.
He's here.
Okay, thank you. And Your Honor, obviously, our office has not had any time to review his police report with him and the evidence. So
Well, what does this say? Except for confidence.
It's just on the bond.
It's here on the bond, on the bond by. And you know nothing about those, I take it.
that's correct, Your Honor.
Is there a report?
Troy, sometimes they're the same. Just saying.
Oh.
That's all.
Counsel approach.
Okay, while they approach,
Okay.
we'll go back to watching. Watching for the judge in Tennessee, good Judge Wolf, there in the Heavenly Wood courtroom. Possibly one of my favorite layouts for the whole bench. It's absolutely beautiful. I like to think it's like a white oak. So we're in picture-in-picture court. How do you want it, Greeners? What should we serve it up like this or like that or a little of that? Then we can switch back and forth as things get interesting. I think we're right here right now. This is one of the amazing features from a little tool that I run on my Stream Deck, made by a guy named Adam Tao, T-O-W. It's a little program that called Mix Effect. Mix Effect. It's worth every penny. Making you dizzy.
Okay, on this matter, the defendant is in custody on this case, I think, as well as others. He's awaiting a review hearing, which is set for July 22nd, 2025. Well, he wouldn't have been in. I think at this point he's being held on this alleged bond violation, because otherwise it wouldn't have occurred that way. So at this point, what I will do is I'll continue the defendant's bond is being revoked for the violation pending a hearing on this. There's a report that needs to be prepared. As well as I have shown counsel the preliminary results, I guess, of the bond violation, which is possession of a weapon. So I'll set a bond violation hearing on this matter for June 26, 2025 at 3 p.m.
Thank you, Your Honor.
All right, thank you. Court calls case People versus Anton Brooks.
Good morning, Your Honor. Wendy Barnwell, standing in for the attorney of record, Mr. Kareem Johnson, on behalf of Mr. Brooks.
Thank you, sir.
Anton Brooks.
You have any? Barnwell speaking. Yeah. All right, what are we doing?
Your Honor, Mr. Johnson needs an in-person PCC on June 26th. He told me that's when he's available. He said, however, because he doesn't have all the discovery.
Oh, hold on. So he doesn't have the discovery. The 26th, he's just asking for an adjournment of the probable cause conference.
Yeah.
Okay, thank you. Probable cause conference will be then adjourned on June 26, 2025, 9 a.m.
Thank you, Judge.
Bond continued. Thank you. Court does call the case People versus Robert Brascom.
Marie Canhouse is the prosecuting attorney on behalf of the people.
Good morning. This is Public Defender Lauren Perny on behalf of Mr. Branscombe. Mr. Branscombe, please state your name for the record.
Robert Branscombe.
Your Honor, we're asking for an exam date, please.
Discovery is complete.
Yes, Your Honor.
People have their witnesses available the 17th.
I believe so, Your Honor.
Preliminary examination in person, June 17th, 2025 at
12 p.m.
12 p.m. That's before me.
Thank you, Your Honor.
Thank you, Your Honor.
Bond continue.
All right, thank you.
Thank you. Court does call the case People versus Anthony Alfaro Siquejas.
Thank you, Richard McDifford.
Honor, Assistant Public Defender Nicholas Bukovich on behalf of Mr. Alfredo Cuejas.
It's a heck of a name.
There yet.
Sounds like he's in custody. You guys, we may watch Lori Vallow this afternoon. It depends if we stumble across another case before then that we want to stick with. I know we're not going to be sticking with Lori Vallow.
Seriously? Not really.
Can't give a bench warrant to somebody who's in custody. Where are they at?
You can say your name for the record.
Anthony Alfaro, KS.
Got it. All right.
At this time, Your Honor, I'll be asking for a brief adjournment. He has another probable cause conference date scheduled with you next week on a new matter that is the basis for the other bond violation. So we were asking for the adjournment to be able to track those cases together.
He has a what?
A probable cause conference with you on June 12th.
On June 12th.
So next week. So we're just asking for that brief adjournment so the cases can track together.
And that case is what result. Oh,
is what I believe is that's bond violation.
That's what I was trying to follow with what you indicated.
Yeah,
so
yes,
we'll deal with that bond violation. I'll grant the adjournment.
Thank you, Your Honor.
I'll adjourn this probable cause conference June 12th, 2025, 9 a.m. Bond continue.
Thank you, Your Honor.
Thank you.
Tag, 29 months. Roses are red, violets are blue. I've spent 29 months with all of you. Tag
Bakovich,
rhymes
that
and the
went
timing
much
is
better
good.
for you than last week.
It did.
Maybe it can continue.
That's the goal, Your Honor.
Tag, one of our OGs, 29 months.
Because when you came up,
Thank you,
I got
Tag.
scared. I just didn't know. Court calls the case, People versus London Daughter.
Andrew Childers appearing on behalf of the people, Your Honor.
Madam Judge, on behalf of Mr. Daughtery.
London Daughter.
Detect Vids, I love that one.
Two cases. What are you looking to do?
Your Honor, we are going to be adjourning. I believe we don't have discovery on one of the cases, so we're waiting to receive that from the prosecutor's office.
I have the 8-port version of that.
I'm presuming that's
the
on its
extreme
way.
version. That's what I use. I use the SDI input instead of HDMI, but that is an incredible switcher. Lets you stream straight to YouTube without a computer. It does have to be hardwired into your network. There's no Wi-Fi built in. Limited to 1080p. Can't do 4K, but other than that, fantastic.
I believe it's the 1318. Our one of the legal assistants or paralegals in our office emailed, I believe Tuesday, and then they looped you in and said, "Have you guys requested it?" It's from a couple of years back, but we don't have discovery on one of them.
A couple of years, you don't have discovery? Who's not doing their job?
All right. Well, what I'll do is I'll adjourn probable cause conference June 26, 2025, 9 a.m. Let you guys try to get that cleared up. I see that the one is a 22 case, so sure they'll be able to find it. But all right.
Thank you.
We'll continue. Thank you, sir.
Thank you. Okay.
Court calls case People versus Jerome Burns.
Morning, Honor, and Assistant Prosecuting Attorney Babbitt.
And Assistant Public Defender Chinasi Kyriak and earlier on behalf of Mr. Jerome Burns.
Nice of you to show up.
That's the one who was
Thought
missing.
I'd throw that out there.
I figured it was coming your way.
Mr. Burns, state your name for the record, please.
Jerome Burns.
Thank you, sir. All right, what are we doing?
So, Your Honor, we are here for two matters today. I think we're doing a sentencing on the bond violation for Mr. Burns, as well as the probable cause conference. In regards to the probable cause conference, Judge, we are asking that this matter be respectfully set for preliminary examination.
You have all of the discovery.
To my knowledge, Judge, yes, we do.
We'll have the witnesses available to 7.
We'll do our best here.
All right, why don't I do this? I'll set preliminary examination June 17, 2009, 9 a.m. Or, well, why don't I do it this way? I'm going to set this one at 12 p.m. for me since I just on the other day. And I'll adjourn the sentencing on his bond violation to that same day.
Okay.
Thank you.
Bond will continue. Court does call the case People versus Tequila. Evans, guy.
Tequila. We've seen this one before, right?
What?
She should be on Zoom.
Tequila's on Zoom?
We've seen Tequila before.
Is she here?
Oh, okay.
I don't see her name. Oh, there she is.
Judge Wolf still not in his robe yet.
Tequila, stop coming down.
She wished she could have.
Sure. Tequila, can you state your name?
Tequila Evans, guy.
Good morning.
Good morning.
All right.
She just woke up.
What are we doing?
So, Your Honor, when we were here last time, I incorrectly filled out the plea form where I said that I was adding count 2 and dismissing count 1, and I meant to put I was adding count 3 and dismissing count 1 and 2. So that is why you're here today.
And it's also my bad because I didn't notice that on the plea form. So it's count 1 and 2 that are getting dismissed.
Got it. We're coming back just to correct the record.
Mhm.
All right. What I will do then is I will sign sort of dismissing counts 1 and 2, accepting the defendant's plea to count 3, and then set the sentencing date.
Judge Wolf just killed his live stream.
I'll set the sentencing date 7/10/25 at 10 a.m. before Judge Washington. And what I will do is I'm accepting the plea to count 3, non-protunct to May 22nd.
We might not get Judge Wolf. He just turned off his live stream. We'll keep an eye on Minecraft Court, see if they bring anything today.
What?
Do we need to turn in the form or not?
Yes, why don't you?
We don't need the advice of rights again, right?
You don't need that.
Okay. Thank you, Your Honor. Thank you, John.
Thank you. That should clarify everything. Court calls case People versus Curtis Damon.
Good morning, Your Honor. Lord Yagi, Assistant Public Defender, with and on behalf of Mr. Damon.
Good morning, Ms. Sharpie.
Good morning. Mr. Damon, could you state your name to the court?
Yes, Curtis Mitchell Damon.
Your Honor, I did fill out a green sheet. However, I am asking if this court would consider allowing Mr. Damon to be released to treatment. He is
To inpatient treatment?
to inpatient.
I'm going to have no objection to any order allowing somebody to be released to treatment.
Okay, thank you, Your Honor. I think that will help immensely, and I know Mr. Damon is really serious about that.
All right.
Oh, and we would request an adjournment as a probable cause conference for him to get into treatment. I think that will help discussions with the prosecution about how to
Do
resolve.
they have a timing to try to get him there, or how's?
I don't have any specific update as to timing.
Well, why don't I do this, then I'll adjourn the probable cause conference to June 26, 2025, 9 a.m.
Thank you.
See what progress they made regarding.
Thank you, Your Honor.
Thank you.
One quick question regarding bond. Because Mr. Damon's tether, I mean, they closed his file essentially because he absconded as far as the scram is concerned. What would be the status of that order? Would the court wait to see if
They closed it. They closed out his tether.
Yeah, we have a report from May 13th, I believe, where they had lost contact with Mr. Damon. He last reported for a scram download April 29th. And so where that particular tether might be located and whether we would need a new order depending on what happens with his treatment. He said he still has it.
And thank you, Ms. McDuffie, for bringing that up, because I actually, in the proposed order I drafted, I did put in all prior bond conditions remain in full force and effect. I didn't mention anything about the tether, so.
Okay, I'm just looking at it.
We're about to make a jump.
That was a GPS tether.
Scram.
No, alcohol tether.
It was a scram tether?
Yes.
Yep.
Okay.
We'll let this one wrap up, and then we're going to jump to Judge Stephanie Boyd down in Bexar County, Texas, San Antonio.
Yeah.
We haven't been in her courtroom in quite a while.
So what I'm going to do is I'll just add it. I'm adding a sentence to the order I signed. He can be released to inpatient treatment program once a bed becomes available with a scram tether prior to release. Okay, so I'll add that, and I will also sign a new order for a scram tether. So that way, if a bed becomes available, he gets a scram tether. Okay,
Thank you, Your Honor.
and I'll set it for June 26, 2025, 9 a.m. Bound and continue.
Thank you. Thank you.
All right, off to Stephanie Boyd.
This is a plea bargain agreement because I followed your plea bargain agreement and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, good luck to you, sir.
Good luck to you. See what sort of mood Judge Boyd is in. See, she's got the flowers in the purse. We jumped in right when it got quiet. Got the tiniest bit of static on this. I need to get fixed. Let's switch to a different feed. There we go. Static is gone now. Got to find where the cable, which cable is bad, which one's getting static.
All right, Aldolf Mendoza.
Yes, Your Honor.
All right, today is our plea deadline date.
Yes, Your Honor. A offer has been tendered. My client is not willing to accept. We're requesting a jury trial date, Judge.
All right, how long do y'all expect this trial to last?
I believe the state will be the ones calling witnesses, Your Honor.
3 days.
3 days would be safe, I suppose.
All right, Ms. Ferguson, I need a jury trial date, criminal trial division, 3 days.
Yes, Your Honor. Thank you, Norma. And I already executed the discovery acknowledgement, Your Honor, and I gave that to the court. So I do have that date of July 22nd, and we shall be here that day of my client.
All right, thank you. Thank you for addressing appropriate for court. Once you sign the reset form, you're excused.
Thank you, Your Honor.
Nicely done. Nicely done. That's the way you do it.
Bravo, your other signature, further in the front.
Who's here on Jacob Kawazawa?
I am, Your Honor. Eric, well, may I bring up Mr. Kawazawa?
Yes.
Morning, sir. Good morning, Your Honor.
Good morning. All right, is all discovery received?
Yes, Judge, and actually, I'm just, state is asking, and I don't believe defense has an objection. I'm asking for 30 days. We do have a third defendant in the case, and I'm trying to get into admin to make a sort of a whole package deal here. And we're asking for at least just 30 days, if that's
Any objection?
No, Your Honor.
All right, I need a 30-day reset on Kawazawa, please. All right, July 7th.
Are you out that week?
No, I get back on the 3rd, so I'm here on the 7th.
All right, so that will be the final chance for you all to reach an agreement. So I'll put that as your final plea deadline date.
Thank you, Judge.
All right, sir, do you have any questions?
Thank you.
You're welcome.
May we be excused, Judge?
Yes.
Thank you very much.
Sir.
Is everybody spot?
Right. She has some pauses in court. I guess she's not super busy. She's not very talkative today. I wonder if she's in a bad mood.
Everything's all right.
Yeah. We'll see if that accident.
Are you waiting for me? Yes.
She's been standing there a long
Good
time.
morning.
I believe on page 10 of your docket is, you're gonna have, Adrian Harper. I learned that Mr. Adrian Harper has a warrant that was issued on 5/22 of this year.
T-shirt?
On a different case of what he is here. I'm guessing that's why he's not here. His attorney is Fernando Trevino. Fernando Trevino is out of state, so he is not here, and I would like to try to avoid the bond forfeiture.
I mean, he needs to be here.
Adrian Harper, I'm pretty sure he's not here because he knows he has an active warrant on something else.
So are y'all asking to get off the
I
bond?
would like to know if maybe a bond increase, a judge's warrant could be issued.
I mean, you all can get off the bond if you want to get off the
Okay,
bond.
we could do that too.
All right, thank you.
Judge.
Sure.
He's in jeans and a T-shirt. I think
Yes.
that is
Hello.
a
Good morning.
Good morning.
bail bondsman.
All right, is he on the docket today? She
Is that
is.
a possibility?
Can I see the file on Phoenix Miller? All right, and Miss Miller, if you could approach. All right, Miss Miller, the state is saying that they're dismissing your case for a missing witness. So that means that they have a witness that they can't get. They're not saying that they don't think you did it. They're just saying a witness is missing. So whatever is occurring in your life, you need to make some changes. Otherwise, you're going to be back into felony court. Don't do that, all right?
Yes.
All right, good luck to you. Thank you for dressing appropriately for court.
Thank you, Judge.
You're welcome. Lorraine, you come in and you're just like, here's my dismissal. Shh.
No.
It's just like, here I am.
Got a dismissal.
Thank you, Judge.
All right, have a good one.
It's always a good day when your case gets dismissed if you're the defendant.
Oh. All right, who's here on Antonio Garcia?
So I've got a little
All right,
confession.
just one moment.
Mrs. R.A. had a bag of like fruit and nuts, like a mixed bag. I went through and I picked all the good ones out. So all that was left was just the stuff I didn't like. Then I asked her to bring me a treat, and she brought me a big scoop out of that bag, and it's all the ones I don't like, but I can't complain.
Okay, just
because I
Miller
ate all
on,
the good
please.
parts.
All right, thank you.
So,
All right. All right, first thing on this case, where are we on discovery?
Judge, I've gone ahead and looked at what's in the state's file. I need to go through the reports to make sure all the videos match. So it's our first setting. I would ask for one more setting.
All right, Ms. Ferguson, on this case, I need a 30-day setting for discovery.
But Judge, we have confirmed the state's reached out to the complainant. We're talking about an offer. There was an offer already, so.
Okay.
we're moving.
All right, July 10th is going to be your discovery date. And I also have a motion to modify conditions of bond.
Judge, we do need to get a setting for that at some point.
All right, are you all ready to proceed on this motion to modify bond conditions? They're asking that the GPS be removed.
Sure. I mean, if defense would like to proceed today, or if they want to reset it, it's up to the court.
We haven't conferred on that, so if we do that, I don't think there'll be an agreement. So I don't know that we're in a position.
All right, so he says that he wants it removed because of employment. Are you all able to agree to partial GPS for employment?
The state would agree to partial for employment purposes.
I'm on partial. I'm
All
on
right.
partial. He's on partial right now. So there is, his ability to work outside those hours, of course, is affected. And so we'd ask for, tracking only. This case has been pending a while. It was just indicted. We haven't had any issues with his compliance with GPS.
Mhm.
There were some issues with drug counseling, but we got that resolved.
All right, state, I don't know how you would feel about tracking. I don't know if you're ready to proceed on it, if they're just asking for tracking only.
Just since it's spur of the moment, we would be opposed to it, Judge. The indictment and prior history purposes.
All right, so let's do this. If there's an issue with your employment, all you have to do is let the court know. The pretrial services officer, have there been any issues? Oh, and sorry, state your excuse.
Thank you, Judge.
With the pretrial services officer, has there been any issues with your working?
Mr. McCory's been pretty lenient, but due to the, I guess, overcrowding or understaffing, sometimes he doesn't get it. So because of these court issues, I haven't been able to do overtime, things like that because of the GPS. I'm not looking to make a bad situation worse. I'm more than confident that it will go, but
And just those are the issues. We haven't had any issues with the complainant. There haven't been any contact issues. Certainly, there's been nothing along those lines.
So has pretrial services, have they told you to let them know within 24 hours if your work schedule? Okay, well, there shouldn't be any problem with the work schedule. What I can tell you is anytime there is, and your attorney will tell you this, anytime there is a pretrial services violation, some type of violation, the first thing I do is I ask the pretrial services person, hey, are they back in compliance now? Because sometimes there's miscommunication. And then if they say, yes, they're still not in compliance, I'll usually have a hearing. I don't just knee-jerk reaction sign things. All right. But whenever you want that set, just let the court know. All right. Thank you.
Thank you. You have a listen.
You too. Yes. Well, I mean, that's what date you gave me. All right. Thanks. Yes, for discovery. And with regards to their motion, council will set it whenever they want it set. And council, please make sure that your client is on time next time.
Mr. Wilkins.
Thank you.
Tony, I did get some cinnamon
Who
roll
is here on
goldfish,
Larietta Homes?
and I ate them all. They're gone.
Good morning, Your Honor. John Robertson from the Films.
All right, are you all ready to proceed on this motion to revoke?
Yes, sir.
Can I have a motion to revoke stamp, please?
I don't need it. I'll have a digital copy.
Jay Quellen? Jay Quellen.
Yeah.
B. Lockey?
Court is calling 2024 CR 2336 State versus Larietta. Nicole Holmes, could I have parties
Ron.
announced?
Andrew Harris Ailman for the state.
John Robertson from Miss Holmes.
And are you Miss Holmes?
Yes, ma'am.
Are you the same Larietta Nicole Holmes who was placed on deferred adjudication in 2024 CR 2336 for the offense of injury to an elderly person with bodily injury on June 13, 2024 for a period of 2 years? Is that you?
What'd you
All
do?
right. You're going to have to make sure you keep your voice up so that I can hear and the court reporter can hear. State?
In Bexar County, Texas, the defendant, Larietta Nicole Holmes, did then and there fail to report to the supervision officer as directed for the months of March and April 2025 in violation of condition number 4.
How do you plead to that, true or not true? State?
State waives the remaining violation allegations.
Any objection to the waivers?
No, Your Honor.
Did you understand by pleading true to violation of condition number 4, the court could find it true, grant the motion, find you guilty, sentence you up to 10 years in the prison and up to a $10,000 fine? Knowing that, do you still wish to plead true to violation of condition number 4?
You still want to plead true to violation?
All right, so here's the thing. You're going to have to speak up. And you need to speak the way you speak when you're not in court before me. So whatever agreement you think you've worked out with the state, I don't have to follow that agreement because this is a contract and it's a contract with the court. It's not a contract with the state. It's not a contract with the defense. So you pled true to violation of condition number 4. Regardless of what agreement you think you've reached with the state, I can revoke you and sentence you to 10 years in prison. Do you understand?
Yes, ma'am.
All right, knowing that, do you still wish to proceed with this plea of true?
Yes, ma'am.
All right, is there a proposed agreement?
Yes, Your Honor, to deny the motion, continue on regular supervision and amend for the following conditions. Immediate placement of GPS monitor for 6 months. Proof of residence or proof of employment with every OV. Don't know what OV stands for. If no proof of employment, then proof of disability. If not on disability, 4 job searches per week, as well as minimum of 12 community service hours performed monthly, immediate enrollment in anger management course, IVR call inline for 4 months, bi-weekly reporting for 4 months.
All right, so here's my question. You want to raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
You can lower your hand, state your name for the record.
Larietta Holmes.
What have you done since you've been on probation?
Since I've been on probation, I did try to finish my classes.
So you didn't finish your classes, you tried to, all right?
For community service, because last time I was here, my lawyer asked if I could I was getting my BA, and he asked if I could use that for community service.
And why didn't you finish that?
A lot in between the time happened, so I did have to drop.
What has happened?
Lights were turned off in November, and it was hard for me to try to get any type of assistance for it because it was overdue and they just turned it off. So in between time, I was trying to find assistance, I was trying to find work, and also trying to maintain my home and keep up with everything that I could, and also raising my 2 children.
So where are your children now? Who's raising them?
My son, he's with his girlfriend, and my daughter, she's with my sister. She works, my son works. Both of them work, they're both of them in school, and they both get good grades.
Okay. So here's the thing with lights being turned off. Back in the day, people didn't have lights. You turn on a candle. And people always assume that where people are in their station in life is always where they've been. Like they never had financial problems or things haven't. I've had my lights turned off before. And you know what? My mom and my grandmother would always say, hey, whatever you do, make sure that you have your If you're living in an apartment, make sure that's paid. If you're living in a house, make sure that paid. If the lights get turned off, if the water gets turned off, at least you'll always have a place to stay. So getting your lights turned off, and sometimes people are like, oh my gosh, that's so embarrassing. It's like, I still have a place to stay. Getting lights turned off happens to everybody. I guarantee you, a majority of the people in this courtroom, attorneys included, deputies included, court reporter included, have at some point
like, hey.
had some utility turned off. One time it happened to me, and it's just because I forgot to pay the bill. And I'm like, hey, why is my water not on? And they said, Stephanie Sauce came out and turned it off. I'm like, oh my gosh, I forgot to pay my bill. And they came out and turned it back on, of course. But that's nothing to be embarrassed about. So, and the reason why I'm telling you this story is because you have to reach out to probation and tell them what's going on in your life. Otherwise, you could go to prison for 10 years. And then who's going to be taking care of your children? Now, what's happening with the new number one in this case?
Judge, I can elaborate on that. That is an allegation based on a voicemail that was left with the landlord. I received a copy of the police report. The landlord sent a copy to the court, and that was forwarded to me by Norma. They took a police report based on a voicemail. And last time I looked, a voicemail doesn't arise to a Class C threat.
What?
So anyway, that'll have to be sorted out. I think that's obviously one of the reasons why we're not going on that today.
All right, so what's happening with this number one?
That's a municipal court problem.
Okay.
So.
All right, probation. What is your recommendation?
Judge, the court summary, according to the sentence summary, is exactly what Mr. Edelman states.
All right. So why were you not reporting? That's the easiest thing, to pick up the phone.
I was communicating with my probation officer. I was
not in March and April.
I was in March and April. I did. I even got kind of scared because he wasn't responding back to me. He never did tell me to come in. Everything that I was going through, far as dealing with the landlord and also dealing with housing, and my life still been not connected. I was communicating with him.
She's not buying that.
So has she been communicating?
Judge, I can check the notes.
All right.
That's one thing we discussed, Judge, is that communication, however the communication is not a substitute for reporting. And I think Clarice understands that.
And my lawyer did make a good recommendation. He's when, communicating, texting, sometimes it's best for me to go down there. And I didn't know that. To set up an appointment, go down there so I could be seen. And that way it wouldn't be no miscommunications.
Was your communication smoke signals?
Judge, lots of office visit in the system indicates February 28th and 2025. There was a text message sent out with an appointment scheduled in March. I don't see anything indicating there was a phone call with me back to the officer, and the same for April, Judge. There were also system text messages reminding his phones, you need to pay your fees. There's some batch emails that went out for services.
All right. This is her first motion to revoke. I'm going to tell you something I'm going to tell you right now. Number one, when your utilities are disconnected, that's nobody's fault but your own. If my utilities get disconnected because I forgot to pay, that's not their fault. It's not the utility company, it's my fault. Your emergency is not somebody else's priority unless they want to make it their priority. And when you have a landlord and part of your contract with your landlord is you pay rent and you pay utilities, when utilities get cut off, that means that you didn't pay them, or maybe the utility company made a mistake. If the utility company made a mistake, then they will come out and correct it. Now with CPS Energy, if they do that, they can turn it on immediately because they've switched out everybody's meter where they can operate it from in office. But when your utilities are cut off, one thing you do not do is on your own try to cut them back on or tamper with meters or anything of that nature. Do you understand?
I would never do that. I don't want to.
No, okay, here's the thing. Don't say that because that's what's in the police reports and everything. And the other thing is, it is clear from the court, based upon what you're on probation for, that you do have an anger issue. And it appears from the court that you don't know how to address your angers when things don't go your way other than lashing out at other people. That is going to stop. Otherwise, you're looking at 10 years in prison. Then the 10 years in prison, you can try and lash your anger out at other inmates. And you know what's going to end up happening? Somebody at the prison, somebody at the jail is going to be badder than you. And they're going to unleash anger on you. So if you don't want that to happen, then you had better change your ways. And this bullying thing that maybe you're doing with people that are older than you because you're on deferred adjudication for injury to the elderly, that's going to stop. And your landlord says that they're 57 and they have a disability and they're having to deal with you. So if you were living at that property, you don't have to worry about not having lights at that property because the court is no longer going to allow you to live at that property and you're no longer going to be allowed to have contact with her. If you have contact with her, a motion to revoke is going to be filed. Do you understand?
Yes, ma'am.
See, and I don't know why you're giving me that attitude now. You know what you did to Miss Holmes, that breathing hard. No, that breathing hard thing. Yes, ma'am. Yeah, that's not going to be tolerated here. Do you understand?
Yes, ma'am.
It's time for you to start showing respect to people, whether you think they're worthy of it or not, because you're landlord. Whether you think they're worthy of it or not, you need to show respect to them because you're living on their property in their house and they can take that away. Do you understand?
Yes, ma'am.
And you need to start behaving differently so that your children will know the proper way to communicate and it's not through violence. Do you understand?
Yes, ma'am.
All right. So you're going to start completing the conditions of your probation immediately. And when you are released, if you don't start enrolling in these programs and completing them, a motion to revoke is going to be filed. Do you understand?
Yes, ma'am.
All right. The court will deny the motion. Alternate amend conditions to the following. Need to get items, you'll need to have someone other than yourself go over there and go with the police escort to retrieve your items. You are not allowed to call her or have third parties call her or have third parties contact her. Other than that one time when that person goes to the location, if you have items there and they need to go there with the police escort. Do you understand?
Yes, ma'am.
You're going to start your anger management classes and probation. What is the earliest she can start anger management?
Give her 30 days.
All right, anger management class are to begin within 30 days. Do you have a disability?
No, ma'am.
All right, she doesn't have a disability, so there needs to be there's no proof of disability needed. You're going to need to get a job. That's how people make it in this world. Nobody's depending on somebody else to pay their bills. You're going to get a job. And if you need to get 2 jobs to make a full-time job, then that's what you're going to need to do. So I'm going to require a full-time job. And for the court, full-time employment means at least 40 hours a week. If you want to get 2 part-time jobs, 20 hours each, that's fine. But you're going to work. And there are plenty of places for you to find employment. But sometimes people think certain employment is beneath them. No employment is beneath you because we all need doctors. We all need people who are going to pick the fruit. We all need people who are going to work at H-E-B or work the fries at McDonald's. There's no shame in that. It's a legitimate job. So proof of full-time employment. within 45 days. And GPS, probation, do you want GPS?
Yes, Judge.
All right, there's to be GPS, waive fees. Do you want full-time GPS tracking? What do you want?
And don't you roll your eyes at me. I'll add that. Light Queen, good morning from
All right,
Van Isle,
partial
Canada.
GPS for employment.
Welcome, welcome.
And GPS is until further notice. And do you still want this IVR hotline? Why are you not going in for your, why are you not going in for your UAs?
To my knowledge, I only felt one that was in.
Why are you missing one? Because when you miss one, you could go to prison for 10 years.
I think the day that I missed that was when I went to the office to see him. And by the time it was time for me to leave to get in my Uber, they were going to be closed. And then I think it fell on the weekend.
All right, probation, do you still want the IVR hotline? All right, monthly UAs.
Like
you're not to miss a single UA. Do you understand?
Yes.
Probation, is there anything else?
She is cracking down on this case. She is not happy. Don't push her. Don't push her.
All right, bi-weekly reporting for 4 months. Is there anything else you need from the court in order to be successful? All right, you better do better. Otherwise, you're looking at going to prison for potentially 10 years. From here on out, we can go off the record. From here on out, anything that you do, you need to ask yourself before you do it, is this something that could result in me potentially going to prison for 10 years? If the answer is yes, don't do it unless you want to potentially go to prison for 10 years. If your answer is, well, maybe it could, don't do it because you could potentially go to prison for 10 years. Do you understand?
Yes.
All right, good luck to you. Thank you, counsel.
It helps. You can share on top of
Morning.
Drug test. Yep. Pee in a cup. That's what UA is. Greeners, glad you learned. Glad you learned. You took good notes during class. I must say, top student. Top student. You don't have to brag that you still retain the knowledge. That's pretty much what it boils down to right here. What's with Greeners wanting death penalty for me being picky about my my trail mix? Does Judge Boyd do house calls? I need her to come talk to our kids. Whoa, what a business model. Maybe I should do that. Maybe I think I could do that. I can give a stern talking to when needed, right? I should just have like a live YouTube channel where people connect via Zoom with their kids, and I give them the what for, lay down the law, and then they pay me. That'd be awesome. It's like $1 million idea there. If you're able to give a good tongue lashing, and have YouTube connection, and have internet connection and camera, you too can have this wonderful business be yours. It's a great idea. There's a guy out there who breaks bad news. John breaks bad news, right? His whole job, people pay him to make calls to tell people things that they don't want to tell them themselves, like I'm breaking up with you, or it's not your baby, or your friend and I are better friends than you think. Things like that. There's a whole world of opportunity out there. That's what I'm saying. Oh, look at this. Look at this. None of these packages are mine, I'm pretty sure. Although I want to open them.
No, I mean, she's just waiting for a referral.
They're all for mom.
Oh, then she's supposed to come back here and there's no bond set for her because no, because there should be a motion to revoke file. All right. Yes. All right. All right, thank you.
The clothing that they're wearing generally indicates a status of the prisoner. Sometimes like a mental health status is one of them.
All right,
Danger
who's here
is also
on
one of them.
Adrian Harper? Adrian Harper. All right, who's here on Randy Thomas?
All right.
Yes.
How about the federal 1001
Yes.
warning?
Parties are agreed there is no further restitution needed in this case. It's already been handled and taken care of by an insurance company.
All right, State, is that correct?
That is correct, Judge.
All right, then, Ms. Abrams, no restitution. All right, thank you. Thank you for coming to court and dressing appropriately.
Yes, ma'am.
Thank you, counsel.
Have a good day.
You're welcome.
What would you call it? What would we call the maybe we call it something like the Set 'em Straight hotline. How about that? Or the correction that's it. It's the correction connection. We will do the correction for you. It's the correction connection.
Right.
This is a
Who's
great
here on
idea.
Christopher Mariscal?
Forget true crime, guys. We can tell people off for a living.
Court is calling 2025 CR 001975 State versus Christopher Mariscal. Can I have parties announced for the record?
Andrew Harris Edelman for the state.
Sam Locke for Christopher Mariscal, ready.
And are you Mr. Mariscal?
Yes, Your Honor.
Counsel, have you received all discovery? Did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Mariscal, did you review the document entitled Application for Community Supervision with your attorney? Did you understand it?
Yes, Your Honor.
And did you sign it?
Yes, Your Honor.
All right, probation, this is an application. Mr. Mariscal, did you review the document entitled True Bill of Indictment with your attorney? Did you understand it?
Yes, Your Honor.
Counsel, do you waive the reading of the indictment?
We do, Your Honor.
State, are you proceeding on the indictment as presented?
Yes, Judge.
Mr. Mariscal, did you review the document entitled Court Admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you're charged with driving while intoxicated with a child under 15 years old? As a state jail felony, range of punishment is 180 days, up to 2 years in the state jail facility, and up to a $10,000 fine. Did you understand?
Yes, Your Honor.
If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, Your Honor.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, Your Honor.
Did you understand by entering this plea, you were giving up those rights?
Yes, Your Honor.
And did you intend to give up those rights and enter into a plea in this case?
Yes, Your Honor.
Counsel, has your client been able to provide you with any defenses?
He has, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes,
Do you believe he's currently confident and was legally sane at the time of the offense?
I do.
Mr. Mariscal, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, Your Honor.
Anyone promised you anything other than the plea?
No, Your Honor.
Are you satisfied with the way you've been represented?
Yes, Your Honor.
Are you a U.S. citizen?
Yes, Your Honor.
Court will find that the defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, Your Honor.
According to the plea, punishment is to be assessed at 2 years in the state jail facility. There's a $1,500 fine and the state recommends community supervision. Did you understand that to be the plea?
Yes, Your Honor.
Defense?
Yes.
State?
Yes.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, Your Honor.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Your Honor.
Counsel, have there been any such motions?
There have not, Your Honor.
Outside the agreement, the state is recommending that your community supervision be for a term of 2 years. There be a TAP evaluation and 100 hours of community service restitution. Did you understand those were recommendations from the state and the court does not have to follow those recommendations?
Yes, Your Honor.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
No contest, Your Honor.
State any evidence.
Should be contained in Exhibit 1 and attachments, Judge.
We've reviewed. We have no objection, Your Honor.
All right, state, you may be excused. Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, Your Honor.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same.
I'm writing my script for my courtroom connection intro right now. Give me just a minute. I'm getting through. I'm getting through it here. Just 1 second.
All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty and the court will find you guilty. Are you proceeding with sentencing?
We can, Judge. I prepared him, said there would be a pre-sentence report, but we're happy to waive and proceed to sentencing today.
All right, anything you wish to say on behalf of your client?
He's done fairly well on bond, Your Honor. He had a glitch in February. There was a positive test for alcohol on his ignition interlock the day after Valentine's Day. Nothing that was above the legal limit, but at that time, the court ordered him to do, how many, was 120?
120
Sober meetings, yeah.
And you've done how many at this point? 150. He continued on himself, Judge. He's got, well, there's one other thing. I wasn't going to bring it up today, but he's got a travel plan out in October, but we can just address that at some other time. I was going to bring that up at sentencing. I believe he's going to do well on your probation, Judge. He's taking this very seriously.
There's also an alcohol awareness class that you had me take after the February 14th, which I took immediately as well.
Okay. And what is the plans for October?
He had previously booked a cruise leaving out of Galveston, going to the Mayan Riviera for his wife's 50th birthday, Your Honor. I told him that we would address that with the court once he'd established that he's a good probationer and that he's not somebody you are worried about.
Well, what I can tell you is I'll allow you to do that. But what I do is upon return, you must do a UA. And what I can tell you, if there are violations for your probation from now until then, don't even bother asking because it's not going to get approved.
That's fine. Yes, ma'am.
All right. The court is going to sentence you to 2 years in the state jail facility, suspended and probated for 2 years. There's a $1,500 fine. That will be probated. There's to be 100 hours of community service restitution. I'm going to order that you continue your sober support meetings. So for every sober support meeting you do, that will be 1 hour deducted from your community service restitution.
Yes, ma'am. Yes, Judge.
All right. There's to be the DWI education course.
Yes, Your Honor.
And counsel, if that's been completed within the time frame where this was pending, that will count. All right, there's to be ignition interlock for half the term. Regular reporting by Zoom or in person. Regular random UAs. And for this, I'm going to do the VIP live because this is very serious, okay?
Yes,
with a juvenile in the car and things could have went so badly.
Oh, yeah.
And I'm going to do a driver's license suspension for 180 days. field visits, 1 time per month for 3 months. Probation is, thank you, proof of employment within 30 days. There's to be no employment as a home health care provider or with minors. And I am going to order parenting classes. And once he completes parenting classes, 50 hours of the community service restitution will be deemed satisfied. Probation, is there anything else he needs? Is there anything else that you need from the court in order to be successful?
No, Your Honor.
All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, Your Honor.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, Your Honor.
All right, we can go off the record. Here's the thing. I know that you understood, or at least now you understand what you did was insane. And I don't mean insane by the legal definition of insanity. I mean insane in that you put your wife's life in danger and your child's life in danger. Your attorney does a lot of DWI cases. I think he can tell you that none of his clients have ever told him, I intended to go out and drink, get intoxicated. Nobody ever intends to get intoxicated. And then for people who end up killing somebody, nobody ever says, you know what, my intention was to go out, get drunk, and kill somebody. But it happens all the time, because once you start drinking and you don't know when to stop, and then you drive and nobody can tell you anything because you think you're all right. And then the next thing you know, you're before me, not for just the DWI, but because somebody has been injured or dead. You understand?
Yes, Your Honor.
And that could have easily been your child or your wife.
Yes, Your Honor.
So it appears to the court, you're one of those people who can't drink. I don't drink. I think it's nasty, but that's just me. So you're not allowed to drink while you're on probation.
Yes,
if you drink when you're on probation, that's going to be a violation. So from here on out, anything that you do, you need to ask yourself these questions. Is this something that could potentially result in me going to the state jail facility for 2 years? State jail facility, that's day for day time. So if you were sent for 2 years, you'd be missing 2 years of your family's life. And if you think of everything that's happened in your life in 1 year or 2 years, think about how much you'd be missing.
Yes,
In this court, I want people to be successful in probation. If there's an issue, let your probation officer know about it. If you feel they're not addressing it, you can always come back to the court. If you feel like you're going to pick up a drink, call your probation officer. They're not going to file a motion to revoke. What they're going to do is they're going to send me a notice and say, we need to have a compliance hearing, judge. He's thinking about drinking, and then we'll address it. But if you're just out there doing your own thing, that's not going to help. Okay?
Yes, Your Honor.
There you go. All right. Good luck to you.
Thank you.
Yes.
One thing that he may need in order to successfully complete probation is an occupational driver's license. So I'll just
yes,
for it after it's filed.
Yes.
Thank you.
His driver's
All
license
right,
is
and
suspended for
probation,
180 days.
Mr. Mariscal, he has a trip planned for his wife 50th.
Almost done with the intro.
He has a lot of apologizing to do to her. I don't know. Maybe she don't want you on the trip. I don't know. So if you want to slip me a note and his wife really doesn't want him on the trip, she just want to be by herself, just slip that to me and I'll deny the trip. But I've already told him he has the court's permission to go on that trip. But if there are any violations of his probation, he's not going. So whether you're allowed to go is up to you.
Blink twice if you don't want him on the
October
trip.
dates, and he's going to need to UA immediately upon return. Is there anything else you need from the court?
Environment.
No, Your Honor.
All right, good luck to you, and thank you for always dressing appropriately for court. And I hope the sober meetings are helping you and you're meeting people.
It's helpful. That's why I continue.
All right, awesome. Well, good luck to you, okay?
Thank you, ma'am.
Thank you.
May I be excused?
Yes, thank you.
Judge.
Wow. He definitely needs an occupational license. Yeah. The wife's like, just
the next
finished her
person
notes.
up is going to be Joe Anthony Grant.
She's waving to the bailiff right here. This
Charles,
paper.
have you turned in your paperwork? I'm,
Can I get a?
after that, it's gonna be Angel Martinez. All right. I'm going in the order in which they give me the papers. Just give me one moment.
Thank you, ma'am.
You're welcome.
Clarification. I think so. I haven't taken this. But Alpha. They don't have any certs. Got a special order of cert. Well. Yeah, I know, yeah. You know, you would think, we get better right every time, but it's actually getting worse. It's crazy. Yeah.
All right, sorry about that. All right, Mr. Grant.
Yes, ma'am.
Hi, so today is your plea deadline date. Counsel, is this going to be a jury trial or bench trial?
Jury,
All right, how long do you think this will last?
1 day.
All right, Ms. Ferguson, I need a
1
jury
day.
trial date, criminal trial division, 1 day. And state if you'll make sure the court has an acknowledgement of discovery, please.
Yes, Judge.
June 24th?
Yes, ma'am.
All right, then. Thank you for dressing appropriate for court. We'll see you back on June 24th. Once you sign the reset form, you're excused.
Right, thank you.
Thank you.
Bring it to me.
All right, Mr. Martinez.
He is not on your docket, so I appreciate the work. We're able to work something out and bring him up early, so I appreciate
No problem.
accommodating, trying to get your docket clean
Hey, I
as we can. Absolutely.
So how's life been treating you?
Well, it's good. Headed to Junctions soon.
Oh,
No.
what county is that?
Kimball.
Kimball County, okay. I'm trying to learn my counties. It's hard. At least when I was in college in Louisiana, I would take the Greyhound bus home. So you would hit every parish. So that's how I learned all the parish.
Okay. I've
All
got
right,
the
are there
intro.
going to be any
Rough.
applications?
We are
Yeah.
applying for regular community supervision only.
Okay.
Not department.
All right, probation, this is an application. Court is calling 2025 CR 002964, State versus Angel Martinez. Can I have parties announce?
Andrew Harris Edelman for the state.
Charles Bunk for Mr. Angelo Martinez.
And are you Mr. Martinez?
Oh, yes, Your Honor.
Counsel, have you received all discovery and did you review it with your client?
We have, Judge.
Court will find that the state is in compliance with discovery. Mr. Martinez, did you review the application for community supervision with your attorney? Did you understand it and sign it?
Yes, Your Honor.
Did you review the true bill of indictment with your attorney? Did you understand it?
Yes, Your Honor.
Counsel, do you waive the reading of the indictment?
We do, Judge.
State, are you proceeding on the indictment as presented?
No, Judge, waiving count 1 and the repeat offender enhancement allegation proceeding on counts 2 and 3.
To which we do not object.
No objection.
All right. Did you review the admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, Your Honor.
All right. In count 2, you're charged with possession of a controlled substance, penalty group 1, water 1 to 4 grams. That is a third-degree felony. Range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. In count 3, you're charged with the offense of unlawfully carrying a weapon with a felony conviction as a second-degree felony. Range of punishment for that offense is anywhere from 2 to 20 years in prison and up to a $10,000 fine. Did you understand?
Yes, Your Honor.
If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, Your Honor.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call, and the right to remain silent. By entering this plea, you were giving up those rights. Did you understand?
Yes, Your Honor.
And did you intend to give up those rights and enter into a plea in each of these counts?
Yes, Your Honor.
Counsel, has your client been able to provide you with any defenses?
Yes,
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes.
Mr. Martinez, has anyone threatened you, coerced you, or placed you in fear to get you to enter these pleas?
No, Your Honor.
Has anyone promised you anything other than the plea?
No.
Are you satisfied with the way you've been represented?
Yes, Your Honor.
Are you a U.S. citizen?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, Your Honor.
According to the plea, the state is proceeding on counts 2 and 3. They're asking that your punishment be assessed at 10 years in the prison. There's a $2,000 fine. State recommends community supervision, and there's to be restitution, if any, to SAPD for drug testing. Did you understand that to be the plea?
Yes, Your Honor.
Defense?
Yes, Judge.
State?
Yes, Judge.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, Your Honor.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Your Honor.
Counselor, have there been any such motions?
No, Judge.
Outside the agreement, the state is recommending that your community supervision be for a term of 8 years. There be a TAP evaluation and 200 hours of community service restitution. Did you understand those were recommendations from the state and the court does not have to follow those recommendations?
Yes, Your Honor.
Then to counts 2 and 3, how do you plead? Guilty, not guilty, or no contest?
Guilty.
State, any evidence to support the plea?
Should be contained in Exhibit 1 and attachments, Judge.
No objections.
State, you may be excused. Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, Your Honor.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states Exhibits 1 and attachments, and the court will review the same.
All right, I'm going to share this with you here in just a minute when this is done. We're also going to jump to a little video Josh got for us from the other day with Judge Middleton. It's a really short one. But just giving out business ideas to everybody. I tell you. No contest means you are neither guilty or innocent. It means that you are not going to plead guilty, but you agree that the state has enough evidence they could find you guilty.
The court will find there is sufficient evidence to find you guilty, and the court will find you guilty of counts 2 and counts 3. Are you proceeding with sentencing?
We would like to proceed today, yes, Judge.
All right, anything you wish to say on behalf of your client?
We believe he's worthy of the plea bargain we ask you to follow.
All right. Do you have any children?
Yes, ma'am.
What are their ages?
I have an 8-year-old, a 5-year-old, and an 11-month-old.
Parenting classes.
And do they normally live with you?
I live with their mom.
All right. When's the last time you had employment?
Right before I got incarcerated.
And what were you doing?
I was doing construction.
And have you ever had any type of mental health issues in the past?
No, Your Honor.
Ever been diagnosed with any mental health issues?
No, Your Honor.
Ever been on any type of medication for mental health issues?
No, Your Honor.
Ever used any type of drugs in the past?
No, Your Honor.
All right, so let me just tell you the reason why I'm asking you that question, because this is a drug case. When you're on probation, you cannot test positive for drugs. So if you have an issue with drugs, now's the time to tell me, because I'm gonna make a notation in the file that you're telling me you've never used drugs before.
No, Your Honor.
Okay, so there should not be any positive UAs, you understand?
I understand, yes, ma'am.
All right. This is what the court will do. The court will sentence you to 10 years in the prison, suspended and probated for 8 years. There's to be regular reporting by Zoom or in person, regular random UAs, Proof of employment within 30 days. A release, there's to be no employment as a home health care provider or with minors. Restitution to SAPD for drug testing. Counsel, if you think the restitution amount is outrageous, let the court know. There's going to be a $2,000 fine that will be probated. 200 hours of community service restitution. The court will waive 100 hours upon completion of parenting classes. How far did you go in school?
I only went to 10th grade, but I got a GED.
All right. And then the other 100 hours will be waived if you obtain some type of trade school certification or higher education. Otherwise, if you don't get some sort of trade school certification or higher level of education, you're going to have to do those 100 hours. And it's going to be 100 hours in the sun. And I know you know how San Antonio weather is since you're in construction.
Yes, ma'am. Yes, you are.
All right. There's going to be field visits one time per month for 8 months. And do you know Savannah Ramos?
Yes, you are.
What is her relationship to you?
She's the mother to my kids.
And Randy Capello? I'm mispronouncing it, Capelo.
No, I don't know.
All right, so there's to be no contact with Randy, RANDY CAPELO. Probation, is there anything else? Is there anything else you need from the court in order to be successful?
No, Your Honor.
All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, Your Honor.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. Do you understand?
Yes, Your Honor.
All right, we can go off the record. So I'm going to tell you what I've been telling everybody else. From here on out, everything you do, you need to ask yourself, is this something that could potentially result in me going to prison for 10 years? If it is, don't do it. If you say to myself, maybe not, maybe I won't get caught, don't do it, because you're looking at 10 years. And you say you have an 8-year-old?
Yes, ma'am.
In 10 years, that 8-year-old will have gone through the most formative years of their life without your being present. You understand? So you're going to have to start on the straight and narrow. Otherwise, you're going to end up going to prison. Now, your attorney in the state obviously wants you on probation. They believe you can complete it successfully. If I didn't think you could do it, I wouldn't have accepted this agreement. So everybody wants you to be successful. If there's an issue, let your probation officer know. If they're not addressing it, you can always come back to court, okay?
Yes, Your Honor.
All right, good luck to you. Thank you, counsel.
All right, with that, we're going to take a little break as we get set for a little bit of Judge Middleton here in just a moment. But I wanted to tell you my intro, my intro to the connection, a correction connection. So the idea behind this is that you have a channel dedicated to giving somebody a whooping over the phone, so to speak. Generally targeting children, and the phone calls is arranged by the parent, and so it goes something like this. Your parent is called the correction connection, where I am right and you are wrong. My job is to tell you how it is, and your job is to sit down, shut up, and acknowledge that the only thing separating you from the whooping you deserve is the fact that I, in addition to being older, smarter, and better looking than you, happen to possess something that you have yet to comprehend, and that is self-control. Now, parents, if you've reached your limit and you had it up to here with your wayward child, but for reasons known only unto the powers that be, have some desire to see your offspring amount to something other than the puddle of disappointment they currently represent, all you need to do is pick up the phone and make a call to Correction Connection. With just a basic understanding of the situation, you can temporarily turn your parenting prerogative over to me, and I will craft and deliver a corrective conversation that will leave your child with a clear understanding of the problems they have caused, the attitude adjustments they must make, and above all, the reality that you, as their parent, brought them into this world and can take them out just as quickly should they fail to comply with every element of my instruction. There you go. That's just the intro. So, you know, just a little bit of a little slight pick you up type thing. I feel like I just got grounded and scolded for not cleaning my room. Yeah, we probably need to make that into a song or something. We'll see. All right. Oh, looky. I'm not sure if I showed you this. Do you see the sparkles? See the sparkles right there? My keyboard does fancy things now. It does lights. Okay. Anyway. So yeah, if you got a kid that needs a talking to, just call, give me a little background, put them on the phone, and get it straightened out. So, let's see. Leo, not from Canton or the state police, Nusky. Adam, does self-control apply to gratuitous self-compliments? No, not for me. See, I am right and you were wrong. That's the part you have to remember. Twice in one stream, TechFlex. What happened was I had an old Apple keyboard that looked very much like this, and the battery went dead, and the charger cord for it I did not know was not working. So I plugged it in. There's nothing on it that says when it's turned on, right? I plugged it in, tried to get it connected. I could not log into my computer. I couldn't do anything because the battery was dead. Turns out once I replaced the cable, I was able to charge the computer and it was able to connect. But I thought I need to have a wired keyboard just in case that happens again. In case it's like crunch time and I need a keyboard that works. So how can I invest, Corey? You've invested just by being here. And look at that. You've got a pink courthouse. You've invested in the correction connection already. Those lights are a necessary function. Right, they do. All right, as we're getting set, we're going to show a little bit of Judge Middleton. He had a moment where he offered a bit of advice and correction and to a lawyer. Let's see if we can.
Mr. Brewer, yesterday. This case is actually going to John Bush. I'm waiting for a substitution back. I represented Benjamin Hopkins, who's named in the report as a co-defendant. And then Ms. Ives represents co-defendant Kearns, and Mr. Gibson represents co-defendant Kearns as well. So it ended up on John's platter. So this was going to be something where we're asking for a reschedule, but I did advise Mr. Brewer to be here today. So.
Well.
You represent a co-defendant?
I had, yes. There's 3 defendants in this. I'm sorry, Your Honor, I do have a call from Daniel that came through at 10:26 saying he was going to be here. So,
Judge picks up the phone. It's always good when Judge Middleton gets on the phone.
Hello, Deputy Tafflinger. Any sign of Daniel Gustavo Barrera? He was supposedly en route by a intergalactic portal.
Cue the portal.
All right, thank you. Bye. He did not come in, so I'm going to do a bench warrant with a 48-hour hold. Change the bond from 7,500 of PR to 7,500 cash assured. He's got, as they cited in the court rule, actually a year, but he's got 48 hours to come in before the bench warrant issues. So he was on the way. That's an hour ago, 45 minutes. All right. Again, like I said with Mr. Gabriel, these cases are a pain in the neck because we end up wasting a lot of time.
and due to that, it's okay for Mr. Barrera to just appear this afternoon and state his decision.
Yes, if he appears, the statute says I
give him a notice and continue it. He's presumed not to be a flight risk. So hopefully he'll show up. We can get the case on track. So I'll hold on to Atkinson and Ornelas, and you tell me what you wish me to do.
Our office needs to know today what's gonna happen, because as the court has already indicated, there's a number of prelims. Our office begins the process of sending out those subpoenas as soon as court's done this morning. We work on getting those printed so they can be served in time to have all these witnesses here. Yeah.
Yep, there's a lot of logistics behind getting a case set for a hearing. All right, let us know before the end of the day what we're gonna do with these.
I'd like to let you know before the end of lunchtime.
All right. All right, that finishes our morning, such as it was. We had some extra duties. We will deal with our treatment court cases this afternoon and possibly one or more of these leftover prelims. All right, Josh, thank you for your help as always.
Thank you.
All right, we're going to stop the live feed and stop the record.
Was that the one, Josh? Was that the one? I was getting some popping on that channel. Hang on. Let's see. Trying to see if that's the one I was supposed to show. That's not it. I'm trying to find the, and I'll get rid of the popping, by the way. Sorry, I was showing on the wrong channel. Pre-exam conferences. Judge Middleton. I played the wrong one. That was just somebody getting a bench warrant, which is great, but not the one we need. How long is the video? 126. Oh, it's this one. Okay, hold please. We've got a better one. 47 minutes. Here we go.
Jim was? Okay.
Waiting for.
Your Honor, Mr. Gabriel is willing to come in and speak with the court. We would ask that it be off the live stream. It can still be an open courtroom, but we would ask that it not be streamed.
All right, thank you.
Thank you.
Are you guys seeing this? Okay. You guys are seeing this. He did not turn off the live stream. Uh-oh.
Oh, yeah, you can see.
Tension in the room is palpable.
Lori, did you get a copy of that test result?
No, did you?
I didn't either. I just heard about it. Just the corrections that she. Oh,
Are we waiting? We're waiting for a lawyer?
Is Miss Welsh here? Okay. You heard the results?
I
She
only
was
heard
positive
of
for
the-
everything. Lori,
Lori,
your client was positive for methamphetamine, fentanyl, cocaine, and
marijuana.
Perhaps something else. Marijuana.
does Autumn have a test result or something?
No, one of the issues is just an instant test.
Okay, pause for a second. Hello? Hello? Hello?
Hello.
Hello?
Yes, sir. Yes, sir. My name is Alex. How are you doing today?
Good.
Okay, that's very perfect. And actually, the reason of my short call is that you already have health insurance with the marketplace. Hello, can you hear me, sir?
Hello. My hearing aid battery is going low. Can you talk a little louder?
I said, do you have marketplace insurance, sir?
I have some insurance from my job. I'm a dog food tester, taste tester.
Oh.
Hello?
Oh, okay. I'm sorry about that, my man. You are good to go. You all set. Have a good day, my man. Bye-bye.
Okay, bye.
Thank you so much. Bye-bye.
Yep, you too. Bye. Okay. All right, we're going to go back. He didn't want to play. We were trying,
But her report back to the court was the defendant was positive for methamphetamine,
fentanyl.
marijuana, fentanyl.
Does it show levels or just?
No, it doesn't.
Just what she's.
It's an instant test, so the levels would have been high because it's not a very discriminatory test.
Well, I think from watching her come in.
bailiff's here.
I spoke with somebody.
The judge doesn't like wasting anybody's time. No judge does. And if it's a lawyer doing this, I've not seen this before. I've not seen how this ends. I heard it was a lawyer, so.
That'd be great. Get her to stay.
Well, it would be like a conditional.
Yeah.
So, I don't know if you've talked to her since yesterday. Maybe.
Are we waiting for someone to come in that the judge is going to rip a new one? Is that what's happening here? They're being obstinate and not coming in?
It's Michigan now.
Oh, yeah.
Yes? Oh, man.
I'm not sure who our go-to person is at the jail. We had Lisa all those years, and I'm
I
not,
don't think there's
I'm
anybody.
not sure we have the same levels.
You know, when I ask clients, when I go over there, they're just like, nothing. They have nothing.
Maybe light a fire under somebody.
I thought there was a lady that was upstairs in the same office as Melissa and Mandy. And she was like the jail liaison.
I'm not sure. I'm gonna reach out to somebody.
The last two people that we requested whatever for, they wanted to argue about insurance. And I'm like, okay, so we're in crisis and they're locked up. What would you like me to do with their insurance? Yeah.
Okay. Oh, there we go. Doors opening. People coming in. Deep breath from Judge Middleton.
Yes. I've got a whole bunch of your other attorneys here this morning, so before you leave, let's all maybe talk about all the stuff.
How many attorneys does this guy have? Are all these attorneys his? He hires all the attorneys? The defendant there in the long sleeve, the green shirt, his lawyer next to him said, a bunch of your other attorneys are here, so before you leave, let's all get together and have a talk. This is the most observers I've seen in a Judge Middleton court. Why the delay? Was he at the jail? Somebody give me the lowdown on this. Where is he at? They do 1 day a week like this now. That's awesome. I love full days with Middleton. That would be awesome. Someone is about to get a whooping, and the judge will be delivering it.
I don't know what we're waiting for.
We're waiting for Mr. Gabriel.
Is there another hearing in a different court?
I'm sorry.
I thought he was done.
He is, I guess I was hoping the court would address.
No, I'm not doing it in chambers, and I'm doing it on a live feed. If he doesn't wish to be here, we'll make a record. I'd like him to be here. He had a position he wanted to state. I never got a chance to explain my position. So no, if he doesn't wish to be here, then I'm gonna proceed accordingly.
We go. Take care.
Oh, he was waiting for the live
As
stream.
far as Mr. Fuller's case, is there a drug test?
Well, I called. We'll address that when everybody gets here. We can't do an instant drug test because we don't have a male certified to do it. We only have Autumn. So I'm going to send him to the day reporting center directly from here. There's a condition of your bond that you test on demand of any police or court officer. The prosecutor is asking for a drug test. I would prefer to have done an instant one. We did one yesterday, which we're going to deal with in a minute, but I don't have the ability to do that. So when we finish here, you're going to go directly to the day reporting center and test, and then we'll deal with the results of your test either when we get them or at the time of the prelim, which is set for next Tuesday at 1 o'clock.
Yes, sir.
All right, good morning. Mr. Gabriel is here, and we're going to proceed. This is in the matter of Pickles versus Karan Duvar Fuller.
Your Honor, this is on the record.
Oh, yeah, good. Thank you. Thank you, Deborah. Laura came in to check. This is in the matter of People versus Karan Duvar Fuller. Mr. Fuller is here with his lawyer, Mr. Ross Truckee. Also present is Assistant Prosecuting Attorney Gary Gabriel and Prosecuting Attorney Deborah Davis. Mr. Fuller was charged in April with being a felon in possession of ammunition. I believe that alleges he had 2 shotgun shells. Anyway, because he is a felon, he's not allowed to possess ammunition, and the matter was charged as a felony. He is on bond on 3 other felony cases, which are all bound over to the circuit court, and he was charged with this. Judge Pattison set the bond at $10,000 cash or surety with certain conditions, including supervision of the Community Corrections Office and drug testing. The defendant was here on, I believe, May 13th for a pre-exam conference with Mr. Truckee and indicated at that time he wished to have a preliminary examination. So the preliminary examination was set for May 20th. And I'm going to represent what I was told so anybody can correct if it's different. At any rate, the defendant didn't show up on May 20th. Police officers were here prepared to testify, much to the consternation of all of us, including me. So I issued a bench warrant and set bond at no bond. I wanted to see you personally. Then I went on a trip. I came back on Tuesday, May 27th. I believe it was, this occurred the following day. I may have my days mixed up. I thought it was Wednesday, the 28th. At any rate, there was a warrant out for Mr. Fuller's arrest for failing to appear at that hearing. He called the court that day after the 20th and said, on the afternoon of the 20th, so I missed my court date. And they said, well, there's a warrant for your arrest. Between the 13th and the 20th, Mr. Fuller came into the court and paid some payments on a payment plan that he was on for some other cases. So between the 13th Tuesday and 20th, they didn't show up. He was actually in the courthouse and paid on some fine. So he didn't show up on the 20th. Then he presented himself at the court. Now, Mr. Truckee or Mr. Fuller, you can fill in the details here. My understanding is Mr. Truckee told him to turn himself in at the jail. Rather than meet him here at the courthouse, Mr. Truckee was here that morning. He told him to turn himself in at the jail. My understanding is, and correct me again if I'm wrong, he went to the jail and sat there for about 45 minutes, but they said they were too busy to book you in. Is that true?
Yes, sir, Your Honor.
So you came from the jail to here.
Went to jail.
So I'm in the middle of a busy morning with a bunch of other stuff going on, and here you are. So you walked, Mr. Truckee walked out the door, you walked in the door. So he was gone. We tried to call him, but he was already on his way to Three Rivers. So here you are. I canceled your bond. It was my bench warrant. And there's a statute that nobody likes. But it's
nobody likes this law.
MCR 6.105. It's actually a court rule. If a defendant wanted on a bench warrant or arrest warrant voluntarily presents himself to the court on that warrant within 1 year, the court must either recall the warrant and schedule the case for a future appearance. It is presumed that the defendant is not a flight risk when the court sets a bond order or other conditions of release at arraignment. So that's what I did. There was another option. You can arraign the defendant if the court is available to do so within 2 hours of the defendant presenting himself. So he'd been to the court between the dates. He called the court the date he missed. He went to the jail to turn himself in. They wouldn't accept him. So I went with option 2 of the court rule, which allows him to be presumed to not be a flight risk and appear, which he did. Mr. Truckee was scheduled to be here this morning. He was late. He did call and said he was running late, but he's here. I didn't give him a PR bond. I simply recalled the warrant and reinstated the $10,000 cash or surety bond that was in effect. So it's like, okay, no counsel was here. Mr. Stickley wasn't available. Mr. Truckee had left. I didn't give notice to the prosecutor. I simply scheduled the matter for this morning. And then went on back about my business because I had other stuff to catch up from being on vacation. So some point later that morning, Mr. Gabriel came into my chambers. I was in there signing some orders and I said, hey, good morning. I got something I'd like to talk to you about. I had a misdemeanor complaint that was handled by their intern that I wanted to check with him on. And he said, I have more important things to talk about than that. And he said, why in the hell would you give Karan Fuller a PR bond? And I didn't have an instant response. But I didn't have a PR bond. I just recalled the bench warrant. And then I said, well, I guess I'm sorry I didn't give you notice of the proceeding, but he just showed up and I cited the court rule. So I set it for today. So Mr. Gabriel was quite upset. He got up and either said, this is disgusting or you're disgusting. And he walked out of my office. And this was ex parte. Nobody else was in there but us. And so I left sitting there thinking either me, now maybe the statute is disgusting or court rule that there's a presumption if they turn themselves in, that they're not a flight risk. If I had done that when I was assistant prosecutor to Judge McManus, Bob Karras would have fired me that morning. When did it become a thing that the assistant prosecutor could come in and tell the judge that he's disgusted by a ruling that he made? I'm not sure when that became appropriate. I don't believe you do it to Judge Stutzman. I don't believe you do it to one of the judges in Kalamazoo. I followed the law. I had an understanding of the facts. I followed the court rule. I set the matter for hearing. He's here today. The offense he was released on was possession of 2 shotgun shells. I don't have the discretion to cancel this bond because Gary Gabriel is mad at him. And I didn't deserve what you came in and said to me. In my career as judge, you've been the most disrespectful attorney to me, bar none. An attorney came to me after a hearing and said, how long do I have to be a lawyer before I can be as much of an asshole as Gary Gabriel was to you? I don't deserve that. And I didn't deserve this. I followed the law. I had a better understanding of the facts than you did. I had a better understanding of the law than you did, and he's here now. Make a motion to cancel his bond in circuit court if you're that upset about it. I'm going to send him for a drug test here before we're done this morning. This violates the canons of professional responsibility. You have an obligation to treat the court with respect. And your other lawyers with respect. And I understand that you were upset, but you left before I even got a chance to explain myself. So that isn't a thing. The assistant prosecutor can't go into the judge's office and say, your ruling sucks. That's not how it works. So I didn't deserve it. I don't deserve it. And I believe I was right, and he's here now. We're going to have a drug test. You have your right for a preliminary examination, which will be next Tuesday at 1 o'clock, and we'll proceed accordingly. So what I expect is you to apologize. I understand that you lost your temper and you're upset about it, and that's to be understood. Nobody liked Court Rule 6.105. It was very controversial with the judges. You either had to let them go or drop everything you're doing and arraign them within 2 hours. And as I said, he had turned himself in at the jail and they wouldn't take it. So I set it for this. So that's all I have to say on the matter. Ms. Davis.
Thank you, Your Honor. First, I would like to say that we were not aware of Mr. Fuller attempting to turn himself into the jail. But that's the first I've heard of it is today. We'll certainly be following up with that. Our belief is that the bench warrant arraignment is a critical stage and that he should have had an attorney. We had made it clear at the last hearing when the request was made that we felt that Mr. Fuller was a continuing risk. He was involved with felonies. He's not new to this system. He knows how this works. He knows where he's supposed to be and when he's supposed to be there. His pattern of behavior towards law enforcement is extremely dangerous, with pleading and eluding and resisting and obstructing. And in order to protect society and give our law enforcement the support that they deserve too, we were asking that his bond be canceled and that he be remanded. The concern is now that he continues to be around people who use substances. So his history and not showing up, I'm thankful that the court is going to have a test done.
Well, let's assume that all that is true. What gives him the right to come into my office and express his disgust for my ruling.
Your Honor, I don't believe that it's not appropriate. I get that. We are in a very difficult situation in our office in light of everything that has happened in the last year and a half. So it's been very difficult. It's been very stressful.
It's getting more
And
difficult.
I think overall, Mr. Gavery has the same philosophy that I do as far as holding people accountable and, you know, taking action so that people know that if they do get in trouble, we're going to hold them accountable and not just allow people to waltz in as, you know, when it's convenient for them. It's not convenient for any of us. And, you know, we do our best to have somebody available at all times so that if there is an emergency hearing, the court can call down and we will get somebody here. So what happened, the way it was described to me was different than what
well, there's two sides to every story.
Correct, and there's perceptions. So I know that Mr. Gavery apologizes for the.
I don't want to hear it from you. I want to hear it from
Well,
him.
I understand it. We'll give him a chance to speak in just a moment, but from the beginning, it's my understanding that the comment was made as far as the whole process, because we feel like we're doing our best to charge, hold people accountable, and show up whenever we can.
Well, we've got a case where he's charged with possessing 2 shotgun shells. Move to cancel his bond in circuit court. If you could, I don't want to hang my nail on canceling a bond for someone who was here in between, called the court, went to jail, and the law doesn't require that I give notice to the prosecutor. I had one of these yesterday. I have one almost once a week. Somebody shows up. So he's here. You're right. He keeps doing stuff, or try one of the cases. He's got 3 cases bound over to circuit court. He got charged with a crime, got arrested again, no motion to cancel his bond in circuit court. We set his bond at $10,000 cash or surety with conditions. So it isn't like we're just saying, you know, please don't do this. But it would have been an abuse of my discretion to cancel this bond for not showing up on a case where he possessed 2 shotgun shells. So I set it for this hearing, and he's here, and we're going to drug test him, and you can have a prelim next week.
Thank you, Ron.
And just for Mr. Gabriel.
First of all, let me say without any equivocation that I apologize for losing my temper, for addressing you more as someone that I have known for my entire career in criminal justice, someone who, with me, taught a number of even elected prosecutors right now how to try a case, how to be a prosecutor, what the ethics are involved in prosecution. In my 45 plus years, I have never been held in contempt. I have never disrespected the court when on the record. I have always prided myself on not only doing the right thing as a prosecutor, but also protecting the community's interests and law enforcement's resources. The comment that I made to you would never, Your Honor, and I think you know this because you and I know each other, our wives know each other, we've spent time on Mackinac, would never indicate my disgust for you as a human being. I have the utmost respect for your career. I do, however, differ with some of your handling of matters, one of which is your live stream, and you are aware that I took an opinion about that the last time I was here. I still come to court when I can. I was brought in here to handle circuit court with the idea that this office might be able to get back where it should be before the last prosecutor dismantled things with his blatant accusations against my present boss. That's why I'm back here. because I believe in this prosecutor.
She is his boss?
I believe she's the first one you've had in a while that wants to do the right thing. And the right thing, just like it was the first time I was here for a while, was to hold the people that are putting a huge burden on the citizens in this community, to hold them accountable. My anger and my disrespect was directed towards a feeling that I have that this court expects a lot of its prosecutors to be here, to just wait, to address things that, as I just conveyed to the chief judge, one of the few counties I've ever been in as a prosecutor or a defense attorney where prosecutors appear routinely at sentencings. It just doesn't happen anywhere else. Why? Because they're busy. Well, we're busy. We have 3 people. One of them is the elected prosecutor, the newly elected prosecutor, who has her hands full just trying to correct the errors of the past year. That leaves me handling circuit court and helping out in district court, while Mr. Robert is helping out in district court and also spending a lot of time in 3 rooms. So yes, there is a lot of pressure on this office. Did that enter into my feelings of disrespect for how this system operates? Yes, it did. It was never directed towards you, Judge Middleton. There are times when I lapse and I have to think to myself to say Judge Middleton, because we've known each other a long time. I will, if I can, be honest now, not that I haven't been up until now. You will recall that while at that prelim, I came in here and I advised the court right away that I had been working and trying to get Mr. Truckee to let me know whether Mr. Fuller was going to waive or not waive, that I had talked to Mr. Truckee about what would happen if I'm going to have to bring officers to come in and sit as what you call kind of so what case. Well, they came and they waited and they waited and we waited. I looked at this young man's record, this 34-year-old man, and I saw bench warrants just like this on the Walmart case and the stolen car case, where he was supposed to be here, and ups, it got adjourned, come back. I think Rhonda Ives, nope, no bench warrants issued. In this situation, what happened from our perspective that day was I appeared at the prelim. I respectfully laid out why I thought it was appropriate that his bond be canceled, that a bench warrant be issued so that he could be brought before the court. And I knew he was going to get another bond, or at least we might find out, A, is he around? People assumed he was. I don't assume anything. All I know is he was supposed to be here. You did a bench warrant. I checked when you were gone because Mr. Robert pointed out the ROA was confusing, that it sounded like he was to be something about arrest, but the warrant was there. So I talked to Judge Pattison. We went to the district court. We clarified the day before he walked into court that the bench warrant was valid. Mr. Truckee had told him to go to the jail. And I knew nothing about him coming in here. Certainly knew nothing about him going to the jail. I knew nothing about him coming into the court when there was a warrant, and nobody in security notified us. What I was notified of was when my prosecutor walked in that morning and said, I just saw Karan Fuller riding a bike or something down the street. What's going on? So I go up to security and they tell me, oh, he came in and Judge Middleton let him go. That upset me. It upset me because I thought that because of the respect that I've always shown this court, my willingness to try to be here to do what I can to help out, that I would have been notified of something when I'm sitting in my office looking at my cases. I want to know why he wasn't here. That's usually what happens in circuit. They get arrested. What were you here? Well, my mother was sick. Okay, we'll reinstate the bond. Something to impress upon people that the court means business. And that's all I ask as a prosecutor, that the message that gets sent through this live stream, through our appearances in court, means something. Not comments like on the record, well, it's not the crime of the century. Or it's a pain in my neck when this happens. Pardon me?
Yeah, he is a pain in my neck.
But he's more than that, Your Honor. He shows disrespect to you, too.
And so do you.
Your statement that you made about, well, it's more trouble to book you in and then book you out. It is. It is. But that's the system that's in place, isn't it?
I agree with everything you said.
And let me finish, and then I'll take my admonition. I do not recall that you ever indicated, or that I indicated a PR bond. I didn't know what happened. All I knew is you let him. They told me that you let him out. I didn't hear the court rule cited whatsoever. That, I think, would have been the thing that we might have done on the record had he been brought in and Mr. Truckee held here or held in the jail and held in lockup until Mr. Truckee got back, because I'm interested to know what kind of contact, if any, he even had with his attorney after he walked out of here. Those are the kinds of issues that go into my decision on whether I'm not going to use additional resources to just simply file a motion in front of Judge Stutzman and bring Ms. Ives in and bring everybody else in because of the multiple attorneys that get involved here. So there are a lot of things that I like to discuss. And I think if you talk to the chief judge, you'll hear that we talk about ways to try to improve the system, to try to make it more efficient, to try to make it work with just 3 of us. So yes, I was angry. Yes, I regret my comments to you, and I regret losing my temper. I don't want to be seen as that way, but I have been doing this for pretty close to 50 years. And I've seen it all. And I've been a judge dealing with parolees going back in front of me on the pro board. I know what it is to disrespect someone, and I feel bad that I did that, and I feel bad that I did it to somebody that I, in the past, considered a friend. I hope you will accept my apology for that and recognize that the frustration that I have is not because I'm lazy. It's not because we don't want to be bothered. It's because we want to try to make the system work for the people in this county, the people that are paying a lot of money. My last comment that I wrote down when you were talking is what you said about the court rule. And I will say, I don't have that memorized. I haven't really experienced that before. Nobody's ever cited it to me. The way it's been handled is what I just outlined. Come in, hear your story, why didn't you do? Ask the defense attorney, what kind of contact did you have? Usually there's the admonition, I'm gonna let you out. You're gonna be in touch with your attorney. You're gonna be on time, not 10 minutes late for court, like this morning.
We went through that.
Okay. And is he, not presumed to be a flight risk? Let's not forget that this case, in which he faces life or any term of years because of his past record, is right on the heels of a case in which he led law enforcement through this little town in a high-speed chase while he allegedly was carrying meth and a gun. So this man is bordering on heading into a lot more serious. And it seems to me, and again, I'm not going to go into comments that you and I had off the record about your past dealings and family's dealings with Mr. Fuller. But yes, I was upset because I have a perception that this is not being treated seriously. And for that, I apologize.
All right. Your apology is accepted.
Thank you.
Within the week, Judge Pattis and I had a discussion just before I went on my trip. about what an asset you were to the prosecutor's office.
Oh, asset. Okay, I'm sorry.
You can try a case in circuit court. You're willing to do misdemeanor pretrials. You show up at sentencing and do appropriate, thoughtful comments. And Judge Pattis and I both believe, I'm sure Judge Stutzman too, that you're an asset to your office. The office wouldn't function without you being there. You and I go back 45 years, which is in part why you thought you'd come in there and unload your anger on me. Yes, we taught a generation of young prosecutors how to be a prosecutor, including our current Attorney General. But this case isn't the one to hang it on. Now, we'll have a drug test, and I have my suspicions of how that's going to turn out. And we'll have a prelim, if necessary, on Friday. When all the cases are in circuit court, perhaps you can file a motion to cancel this bond.
I will.
But that's up to Judge Stutzman, and he's got multiple counsel. I think there was an effort to try to do everything together. Anyway,
Your Honor.
I regret that this whole thing happened. I discussed it with the chief judge when he got back, said, how should I deal with this? I don't think it deserves a grievance. All I wanted was an apology, and I got one. And the case will move forward, and the defendant is here as under the court rule. And I said, nobody liked that court rule. It was probably the least popular in the whole criminal justice reform package. But I'm bound to follow the law. Yes?
You had mentioned the prelim on Friday.
Excuse me, I'm sorry.
Okay, just want to make sure.
No, Tuesday, I don't want to make any further confusion. Tuesday, June 17th, 1 o'clock, Mr. Fuller, you're to be there at that time. I want you to go directly from me.
I'm sorry, June 17th or the 10th?
Boy, I'm all screwed up. June 10th, next Tuesday,
All be on the same
June
page.
10th, not the day we've been using for the others. Once you go to the day reporting center right now, and we'll do an 11 panel test. We'll figure out who's going to pay for it.
11
But it'll
panel.
be paid for.
Yes, sir.
Then
If
it may
he's got
take a
drugs
few
in the
days
system,
to
it's
deal
gonna
with that.
find it.
We'll deal with the results of that. At your prelim next Tuesday. All right, you're free to go. We'll let the day reporting center know that you're coming. Laura, will you call them and tell them Mr. Fuller's gonna stop there for a 11 panel urine test?
Thank you, Your Honor.
Thank you, Your Honor.
This matter is completed. Let's bring Ms. Welch in and deal with that matter.
All right, we're gonna fade that one out. We're gonna listen to the other one, the other drug test that was tested positive for everything. Wow, Josh, thanks again for another banger of a clip from Judge Middleton. That just happened this week while we were watching Karen Reed. So very, very recent there. Interesting. One thing I love about Judge Middleton is how much he knows about everybody in the community. He knows everyone and their families. I mean, he knows the defendant. He knows the defendant's family. He knows the assistant prosecutor, and they grew up together, and they've been on Lake Mackinac together, and they've been fishing trips together or wherever. Wow. Can you name all the drugs that show up in the 11 panel test? I don't. I'd have to use AI to find out. I'd have to Google it. Was a banger. Great moment. I think the judge did the right thing though there. Even though that happened, even though the offense happened in private, I think it was right for him to bring that out in public and say that's not okay. You can't do that. Where's my camera? So uncamera-y. All right. Okay, it is 12:31. We have a couple things coming up. I think Lori Vallow has some opening statements in that case. It's this morning there, this afternoon here. So that's happening. I have not yet checked to see if we'd be able to get a feed there or not. So there's a possibility we'd watch that. We're not sticking with that trial throughout all of it. We're going to be going back to Karen Reed tomorrow. But it's been a great break here. Mackinac Island. Isn't that, island, that's fishing, right? People are making suggestions. Ben's meth and opioids. Opiates, benzos, meth, coke, weed, fentanyl. What else is there? Where does acid fall on that one? You know that in my substance test I get to choose, I get from my doc because I'm in pain management, they can see the amount of tobacco in your system. They literally test for everything. 3 pages of stuff. Pronounced Mackinac. Mackinac is a term for a large lake trout. Red, thank you very much for being here. Appreciate you very much. You add a lot to the channel. Love it. Thank you, thank you. Enjoy your time off. Acid reflux, they might test for that as well. They might test for a little Pepto-Bismol. Mackinac is pronounced Mackinac. Don't go. Yeah. All right. Great use of the music. Thank you very much. That was fun music. I probably should have, ideally, see the song? Let's see. The song is 2 minutes and 53 seconds long. And if you can time it perfectly with the end of somebody's statement, the thing I like about this piano song is it naturally follows our like built-in rhythms of how we form arguments, especially apologies and sad stories. And so the crescendos and decrescendos are a very natural flow, and it's amazing. It's amazing how well it fits. If I know when the apology ends and we back the song up 2 minutes 53 seconds and play it then, it is incredible. It sounds like it was composed for each argument that it's played to. I love this song. I don't know what it's called. You can Shazam it and maybe hear it, but I don't know what it's called. It is from the YouTube library. So that was my mom's favorite song. When RA apologizes to Miss RA, he times 2 minutes 53 seconds for maximum effect. It's true. It's true. I do. All right. All right. Wonderful. All right. It is Thursday. It is Podcast Thursday. We have a podcast tonight. Thomas has put in a ton of work. I'm going to put in a little bit more this afternoon just to get caught up on everything. But we are, let's see, it's June 5th. It's the first podcast of the month, which means we're giving away some memberships tonight. So you don't want to miss it for that. If you're hoping to find a gifted membership coming your way, please be there. We may be back here this afternoon here for Lori Vallow or some other court hopping. Depends on what availability is on the court feed. I still have some work to do on that, so I can't promise we'll have Lori Vallow, but that's my goal. To hear at least the openings, to hear what the case is about. It's not a murder trial. It's an attempted murder trial, so it's a little bit different. And then, of course, the podcast tonight, 8 o'clock on this channel. Thomas and I will be here to entertain and maybe, to your chagrin, we'll be here. Probably dad jokes will ensue. We now find explanation for his decline this past year. Time to buy glasses. His faith. Good luck. Good luck. Get some nice ones you like. We are going to eat. Yes, it's lunchtime. It's time to grab some food. All I've had is that terrible mix of fruit and nut stuff that I picked all the good stuff out of. So I just had I had little dark chocolate bits and a little bit of pumpkin seeds and things. I mean, they're good, but it's not the good stuff. So anyway, tonight when you go home, please hug the people you love, smile at someone, make their day just a little bit better. Please stay safe till we go live again. I think we're going live after lunch, but I can't tell you what it's for, so just hang in there. We'll see you guys after lunch. Bye-bye.
Because he's the guy. How does he do that?